Good morning, everyone. Thank you for being here. My name is Greg Bowman, and I have the honor and the privilege of serving as the Dean of the WVU College of Law, and I'd like to welcome you to today's Law Review Symposium on Education Law at the College of Law. West Virginia University is a public land-grant institution of higher learning, and we are proud of the role that we play. And at the College of Law, we are proud to be part of this great comprehensive university and proud to be training lawyers and leaders for the future. And as all of us who have dedicated our careers to education in this room, we do all know, I think, that we are at a pivotal time in the history of our country for education and for the values that we hold dear and that are embodied in education at the primary and the secondary levels and higher education. So, really important topic. We could not have timed things better. You only time the market by accident, and we had a teacher strike again this week. But with the 40th anniversary of the Pauli decision, with last year's teacher strikes in West Virginia, that became a leading moment in the nation. And then again, this year we have a lot to talk about, and it's an incredibly important topic. And we have educators and lawyers from across the country who are with us here today. We welcome you, and we look forward to having the conversation about this topic today. I want to thank a few people before we begin. I want to thank my colleague Josh Weishart, who has been really spearheading the planning for this symposium. Also my colleague Sean Tu, our Associate Dean for Faculty Research and Development. Staff who have been centrally important in putting together this detailed event today, and also the students of the Law Review. Law Reviews are student-led, they are student-run, and they're a really wonderful part of any law school in the U.S. and certainly of our law school. So we thank them very, very much. So thank you for being here. I look forward to a wonderful program today, and I will turn it over to my colleague Josh.
Thank you, Dean Bowman, and thank you all for joining us. Well, like most academics, I find it difficult at times to get people interested, much less excited about my research. No matter how many times I tweet and retweet and share and tag and hashtag and whatever one does on LinkedIn. I've used all manner of clickbait and even video promos and for old schoolers, the traditional op-ed. But I'm not going to stop because the subject of my research is education rights and state constitutions. And damn it, that really is important. We tend to think of the U.S. Constitution as the repository of all of our rights, when often it provides just a floor of constitutional protection, and state constitutions set a higher ceiling of safeguards, and the space in between is filled with all sorts of possibilities. Well, we've assembled a panel of preeminent national experts and practitioners who are as convinced as I am of the importance of state constitution education rights, and perhaps by the end of this discussion, you will be as well. Scott Borges is Associate Dean and Professor of Law at the University of Kentucky College of Law. He is the author of numerous law review articles, books and book chapters on, among other things, state constitutions and education law. The Education Law Association recognized Scott's exceptional work with the Joseph C. Beckham Dissertation of the Year Award. In a former life, Scott taught English and coached soccer for several years in both public and private school in Florida. He was also a school district administrator and curriculum developer. Add to his frontline teaching and administrative experience, Scott has a PhD in educational leadership and policy, and he also earned his law degree from the University of Florida. And I'll say on a personal note that Scott encouraged me early on to pursue my interest in education rights and has been a constant source of support ever since. Mark Dorson is the co-director of the Julius L. Chambers Center for Civil Rights, a nonprofit law firm focusing on housing discrimination, environmental justice, political participation, and racial disparities in education. He's also an adjunct professor of law at UNC and a chairman of the Orange County Board of Commissioners. For nearly 10 years, Mark was a managing attorney at the UNC Center for Civil Rights until the Board of Governors banned the center from engaging in legal advocacy because it was just too effective at advancing the cause of civil rights. I imagine Mark wears that as a badge of honor. Mark earned his law degree from the University of North Carolina at Chapel Hill, and he has a master's in history as well. Zoe Zavitsky is the Deputy Legal Director for the Children's Rights at the Southern Poverty Law Center, where she oversees litigation and policy work focused on guaranteeing vulnerable children access to educational resources and health services. Zoe's previous experience includes serving as a civil rights attorney in the Educational Opportunities section of the Justice Department, where she focused on developing the DOJ's school-to-prison pipeline practice. Zoe is a Harvard graduate, and even more impressive, she earned her law degree from the University of California, Berkeley School of Law, my alma mater. David Chiara is the executive director of the Education Law Center in New Jersey, which works to improve educational opportunities and outcomes for low-income students, students of color, and students with special needs. I don't mean to age you here, David, but you were litigating cases before Pauli was decided 40 years ago in 1979, and before I was born that same year. Yes, for my students in the room, Weishart at 40. David has litigated to enforce access for low-income and minority children to equal and adequate education under state and federal law. He served as a counsel in New Jersey's landmark education rights case, Abbott versus Burke, which the New York Times described as the most significant education case since Brown versus Board of Education, and second only to Paulie. That's my ad lib. David has served on the Federal Education Equity and Excellence Commission, authored numerous publications on school finance, educational equity, and assisted as consultant or co-counsel on several pending school finance cases. David is a Berkeley graduate as well, and he earned his law degree at Temple University School of Law. Please help me welcome our panelists. So based on feedback from our panelists, I'd like us to think about this discussion with three broad themes in mind. So first, what is the nature of the right to education? What purpose is it meant to serve? And is it currently serving that purpose? Second, what's the role of courts in enforcing the right to education? And third, the political and social forces that are shaping the future content and scope of the right to education. What will be the remedy in the cases that come? And to make some headway on that first theme, let's begin with Pauli. We had an excellent panel discussion yesterday on Pauli's lasting influence on West Virginia education law and policy. But today, we will think about Pauli's influence far beyond West Virginia. And David, you have witnessed firsthand the progression of education rights cases in state courts. Can you help us situate Pauli in that historical context and tell us what you think is distinct and influential, even today, about Pauli's conception of the right to education?
Okay, so thank you. I hadn't looked at Pauli in a while until the other day, preparing for this event, and I didn't realize it was decided in 1979. I thought it was later than that. So I was kind of surprised by that. So historically, in terms of the development of education rights in the courts, Pauli is really a bellwether, actually, case in the country. Up till that point, there had been litigation in the states, Serrano versus Priest, Robinson versus Cahill in New Jersey, and other decisions. But those cases were really focused a lot on dollar equity, what we call fiscal equity, trying to equalize resources across districts. It was a lot about the money in the system, the reliance on the property tax and so forth and so on. And Pauli comes along and really kind of, breaks through to a whole nother level. So if you read the decision isn't so much about dollar inputs. I mean, there is discussion about the formula and the disparities that the formula creates, and the need for the court on remand to look at the reliance on local taxes and the extent to which the state is putting in money and so forth and so on. But the court's articulation of what a thorough and efficient education means for West Virginia school children, which is your standard in your Constitution, similar to New Jersey's, by the way, and Pennsylvania's, that the state has to, essentially the legislature is responsible to provide a thorough and efficient system of free public schools. It's a kind of common formulation of education rights in a number of state constitutions. The court's definition of that, putting the sort of meat on the bones of what a thorough and efficient education means, when you think about it in 1979, is frankly extraordinary. It's a bit of a precursor to cases that came along right after that. Abbott versus Burke, which was decided in the late 80s and then went up to the New Jersey Supreme Court in '91, and of course the Rose case in Kentucky, which Scott will talk about. Those are a decade later and follow on and build really on the foundation that Paulie put down. And just a couple things about the court's definition of what rights West Virginia school children are entitled to under the thorough and efficient clause here, because it's not only important, obviously, for children here, but also, as I've mentioned, had significant implications on the development of not just education rights but education policy over the following 2 decades into this day. So the court talks about, first of all, education being a fundamental right, which is really important. So it's not, the court declares that the right to education is fundamental, which means that the court is going to, as you know, courts are going to look at challenges to state statutes and state policies at a heightened level. But more importantly, the way they define what a thorough and efficient education has to include is really, as I said, a precursor to what we saw develop in the 90s, decade and a half later, around standards-based education. That came in full bloom under No Child Left Behind. So the court talks about the development of each child and his capacity to literacy, mathematics, knowledge of government, self-knowledge, and knowledge of his total environment, to allow the child to intelligently choose life work and know his or her options, work training and advanced academic training as the child may intelligently choose, recreational pursuits, interest in all the creative arts such as music, theater, literature, and the visual arts. I love that one. And social ethics and so forth and so on. And then also important services, which often gets lost in the discussion about space and facilities, good physical facilities, instructional materials, and personnel. And finally, that the state has an obligation, the court is saying, to make sure that the resources, that there's the capacity to use the resources in the system at the local level effectively and efficiently. Well, there you have it. So this is a court, this is a decision that's not about basic skills, that's not about minimally adequate, sorry, South Carolina folks that are here, not about a low bar. This is about a well-rounded, rich, and rigorous curriculum that gives kids a meaningful opportunity to learn in a variety of subject areas, not just mathematics and English language arts, which is the usual focus, but social studies, civics, citizenship, the arts, all of the things that tie children to school that are so important. So this is a definition of a well-rounded education that the state has to provide kids, and it's got to do it in buildings that are conducive to learning, to providing and delivering this education. And the state has the ultimate responsibility, as the court says, I just love this. Careful state and local supervision to prevent waste and to monitor pupil, teacher, and administrative competency. So, to just finish, Paulie's influenced then this definition then. You see it then take root in cases like Rose and Abbott versus Burke, and fast forward other cases that are more recent, Kansas, the Gannon case, and these cases in various states, and even today, cases that are being brought now, such as in Pennsylvania, the William Penn case, which is going to be going to trial soon, so forth and so on. These are all about not just looking at dollar inputs, how much money is going into the system, but is the system responsive to student need? Is the system providing a full, rich education to children that prepares them for citizenship, prepares them to be productive contributors to the economic life of a community, and so forth and so on? And is the state really providing all of the resources that are necessary in order to enable children to achieve? The last thing I'll say is that this is a precursor to what happened in No Child Left Behind. You know, when you think about this, No Child Left Behind was the point at which the federal government said, look, if you're going to get federal money, this is in 2000, states have to put in place curriculum content standards, performance assessments, and accountability measures. They left off resources, unfortunately, which is why, which is still the problem, right? They didn't talk about opportunity to learn, the resources that would give kids opportunity to learn. But the point about that is that Paulie really was a kind of touchstone for what happened with standards-based reform in the United States, which is that the states no longer, in the implementation of their constitutional obligations, were going to just sort of sit back and, as they had for decades, delegate the sum and substance of education to local school districts. And that's what states did prior to Paulie. They basically said, you know, the local districts, curriculum, whatever you, testing, all of these things, and even money, because a lot of these formulas relied on local money, sort of state delegating its constitutional obligation down to its local constructs, the school districts. And what Paulie is essentially saying to the state is, no, you're not going to do that. This is the definition of the education that all West Virginia children are entitled to. And the state has an obligation to ensure that its local school districts, which it controls, which are creatures of state policy, are meeting a rigorous, robust definition of what a thorough and efficient education is. So this is a real sort of breakthrough in not just education rights development, but education and policy practice across the sort of American landscape.
Right, and as you said, it was ahead of its time in its conception of the right as it containing both an adequacy component and an equity component. And as you pointed out, it continues to be relied upon and cited by other state courts even today. Scott, I want to bring you in there. Your scholarship has paid careful attention to the text of state constitutions and judicial interpretations of the text. Tell us how Paulie stacks up among the cases you've studied.
Okay, so I don't know if this is on, but yeah, it is. Okay, so in my initial response to the email, after I read Paulie again for the first time in a long time, I've been writing about these cases for over 10 years now, and Paulie was always sort of like a signpost along the road, and it had been characterized, I think, inaccurately as a pure equity case during the time when people were characterizing these cases. There were a series of I guess probably the first one to really put the flag in the ground on setting down waves of litigation was our general counsel at University of Kentucky, Bill Thoreau, or one of the early ones anyway, one of the ones that gets most cited. And so the metaphor that he either borrowed or came up with in that article states that there were 3 waves of school finance litigation. Now, we're all sort of skeptical of this characterization now, but it's helpful in figuring out how Paulie was mischaracterized and how I've come to see it today. So the first wave was in federal court, that if you're familiar with the case San Antonio versus Rodriguez, which held that education was not a fundamental right under the federal constitution and that wealth was not a suspect classification under the Equal Protection Clause, and therefore basically approved Texas's wildly unequal school funding system, or at least allowed it to go forward. That shunted all school finance litigation, at least for a time, into state courts, where originally, I've argued due to path dependence, we proceeded along those claims in the same way that Rodriguez attempted to proceed. We tried to put together equal protection claims based on fundamental rights and suspect classifications. Some of them succeeded, some of them failed. Everybody up until recently sort of put Paulie in that category, because Paulie talks a lot about equality, but Rose talks a lot about equality as well. As Josh has argued very persuasively, equality and adequacy are not really separable concepts. You know, they're interlinked with each other. But Paulie probably should have been characterized as sort of a fulcrum between equality and adequacy in that early scholarship, and I think people are starting to see it that way now. So there's two reasons for this. One is that Paulie is, along with Robinson versus Cahill, which in New Jersey, which was a case that was purely along the Rodriguez line in terms of the way that it was originally litigated, but it also took state constitutional language seriously. Paulie takes the state constitutional language seriously, tries to figure out what it is that thorough means, what it is that efficient means, not just looks at the school system and says, this is bad, let's find it inadequate, like a lot of cases seem to do in the sort of latter era of the adequacy wave. So Paulie was originally placed in this category of equality cases that were sort of Rodriguez copies, but I would argue that it actually is the beginning of the adequacy wave, such that there is one in school funding litigation, and that there would be no Rose if there was no Paulie. Paulie sort of laid the groundwork for Rose. So we're at Paulie at 40 right now. We're also at Rose at 30 right now, and Borie's graduating from high school at 30, right? Josh at 40. Right?
Thank you.
So that's where we sit, right? And so Rose, when you read Rose discusses Paulie at great length as sort of the governing precedent in the area. So this is really interesting, because this is something that doesn't happen in federal constitutional law, but does happen in state constitutional law. In federal constitutional law, if one of the justices said, well, France does it this way, and France has similar language in its constitution, and France interpreted that language to mean X, so we should defer to that, or at least find that persuasive and interpret our constitution to also mean X. That would light people's hair on fire. People would be apoplectic if the Supreme Court did that. And yet, in state constitutional law, we have a bunch of quasi-sovereign entities, each of which has its own constitution, and they constantly borrow from each other, not just in interpretation, but in language. You have thorough and efficient clauses in 6 or 7 different state constitutions, and they clearly read each other's constitutions and borrowed that language from each other, right? Which is really interesting, right? It means that they're not situated the same way as the United States and France. They're kind of situated in sort of a similar way to the common law courts in the United States, right? So they borrow not only language from each other, but then they look at that language and see how each other interpret that language, and then they defer to interpretations of that language the same way common law courts would do throughout the United States of America. And Paulie began that sort of methodology in the area of education clauses. It relied a lot on the New Jersey case and looked at what the New Jersey case did with its thorough and efficient clause, and both as to justiciability and as to trying to figure out what the role of that clause was in the case, and used it the way a common law court would use persuasive authority, which would be highly controversial if we did that at the federal level. Okay? So that's point one, I think, about why Paulie is important. Point two is that Paulie also analyzed lots of other stuff besides text. In addition to looking at precedent, Paulie analyzed the school system in general. It didn't go as far as the Kentucky Supreme Court did, because Paulie was a remand. So the Kentucky Supreme Court in Rose ended up adjudicating the entire state system to be unconstitutional as a matter of Supreme Court precedent, and based a large part of its decision on testimony of experts like Kern Alexander, who testified in the case about what the meaning of the Constitution should be in light of education practice across the country. That's not something you see in Paulie, and actually I think that is something that is one of the things that made me skeptical about Rose and makes me like Paulie better than I like Rose as a matter of constitutional scholarship. But Paulie put the flag in the ground that we have to take state constitutional text seriously and try to give it operation. And I think one thing to think about going forward, if we want to talk about other cases in the panoply of school funding litigation, is that Paulie had some pretty good language to work with. Paulie wasn't trying to define the term sufficient or ample or high quality. Paulie was trying to define the term efficient, which has a very well-recognized meaning, and the term thorough, which may not have as well-recognized a meaning, but it certainly doesn't mean minimal, right? In any dictionary that you consult, thorough does not mean minimal. It does not mean basic. It means fully comprehensive or something close to that, right? So Paulie was working with some very good constitutional language. I would argue, and we can talk more about this later, but I would argue that other state Supreme Courts are working with language that's a little bit more difficult to place a real meaning on. So.
Yeah.
So just in the interest of making this more of a conversation, I really appreciate the point that Scott's making about that transition from equality to adequacy and Paulie being the fulcrum. I think what we're seeing now in the current era or the later era, at least in North Carolina particularly, is an effort to try to bring some of that equality discussion back into this these school financing cases, particularly because what we see is that the disparities that are produced by the funding inequities fall particularly hardest on students of color, low-well students. And so in North Carolina, for example, in the Leandro case, one of the things when we actually intervened in that case on behalf of African-American parents and students in the Charlotte-Mecklenburg school system. And one of the goals was to use the language of Leandro about, which in the North Carolina case made a particular reference to at-risk students, defining them, students from a low-wealth family, participants in a free and reduced lunch program, limited English proficiency, a single-parent household, and that those students were particularly being failed by the North Carolina funding model. So one of the things we were trying to do, and we've continued to try to do, not as successfully as we'd hoped, is to bring that equality piece back in and to say that, again, as a fundamental right, so you've got this heightened scrutiny, to highlight the racial disparities in particular without having to go through the equal protection argument of proving intentional discrimination. That's proved harder to do, but I think at least what we've been trying to do is bring some of that equality aspect back into the discussion. So I really like that framing, and I think that's going to be a critical element, at least in North Carolina, in helping move this forward.
Another way to frame this, and Zoe, you noted that Paulie doesn't focus on one word in the education clause, in the West Virginia education clause, a word that you believe is critical in terms of the purpose of the right to education, and that word is free, right? So can you explain the significance of that word?
Sure. So I'm going to do something that I would tell my staff and certainly law students to not do, which is I'm going to read some stuff. I'm going to try not to just read at you, but I want to not forget the points that I wrote down because this is an emerging area that we're focusing on. So please do not follow my example. Just to frame a little bit what we, the Southern Poverty Law Center, are doing on this panel of distinguished education lawyers and scholars. Southern Poverty Law Center is a civil rights nonprofit based in Montgomery, Alabama, and we fight for the rights of vulnerable folks, especially children, across the Deep South. So I lead our children's rights work in that region, and we have identified 3 primary areas of focus: stopping the school-to-prison pipeline, fighting for educational equity, and protecting children's access to health and mental health services. So this conversation today is very much in the bucket of educational equity, which we think of as basically having 3 key components. First is access. Can you even enroll in school in the first place? Are you prevented via segregation, via discrimination, et cetera? Once you do enroll, what do you receive? Do you actually receive a quality education, and is that quality differing based on a protected status? And then the third component is really thinking about how do we protect our system of public education? Public education, I'm sure it's no surprise to anyone in this room, is under attack by the forces of privatization, both here in West Virginia and across the country. I was fortunate last night to hear from your own Professor Taylor that the teachers in this state are continuing to protect the public in public education, and that thus far you have beaten back efforts to privatize your system. So West Virginia leads the nation in that regard, as I'm sure many others. This is my first trip to West Virginia, so you'll have to educate me later on the other ways in which you lead the nation. But the word that was mentioned that I do think is very important to think about in this context is free, because the freeness of public education is one of the most common components of state education clauses. There are 11 clauses that use the phrase thorough and efficient. There are 26 that use the word free in describing public education. It is an incredibly important component of what we think of as public. So thinking first about the history of free schools in this country. Prior to the American Revolution, there weren't really any free schools. After the Revolution, there were some common schools established, mostly in New England, and some of them were free. For the most part, they were not. And even the ones that were free, of course, did not educate women like me or people of color, really anyone except white men. And so it really was not until the Civil War and the Reconstruction era that we began to have a system and a value of free schools, although to give credit where credit is due, a gentleman named Horace Mann is probably the one that we should all give credit for the notion of free public school, which, although it is challenging to say in this particular moment, he actually stole from the Prussians. In any event, good ideas come from all kinds of places. So around the era of the Civil War, black folks were pretty much not only not permitted to attend public school, they were not permitted to receive any form of education in general. And so there were a number of schools established to educate slaves, but for the most part, they were underground, they were secret, they were private, and many states would punish African Americans who were receiving education or anyone who provided it. So one of the very fascinating components of the Civil War was that General Sherman and General Grant were two of the first to actually found public schools to educate black folks with the idea that as part of the movement to win the Civil War and end slavery, that providing education was a core component of it. And then, of course, you get the Reconstruction era, and then I want to get the name right. We usually think of it as the Freedmen's Bureau, but the full name was the Bureau of Refugees, Freedmen, and Abandoned Lands, which was a huge, huge public works project in the Reconstruction era that did a number of things to help tried to help establish equality for a newly enfranchised class of people in this country. Among other things, they did a huge amount to establish schools. They established over 1,000 schools in the nation. They rented buildings, they provided textbooks, and they actually provided police protection, military protection to those who were violently opposed to literacy for black folks. So that was the era in the Reconstruction era when you began to see a real value on the freeness of public education and the access to public education for everyone as a core component of citizenship, of liberty, etc. And that's also the era when you start to get new state constitutions, which include the word free. And free is a core promise to the newly freed slaves. So, for example, the Mississippi Constitution of 1868 says, as the stability of a republican form of government depends mainly upon the intelligence and virtue of the people, it shall be the duty of the legislature to encourage by all suitable means the promotion of intellectual, scientific, moral, and agricultural improvements by establishing a uniform system of free public schools, etc. Virginia has very similar language. These constitutional provisions were actually specifically, well, we argue in a lawsuit in Mississippi, codified by their full readmission to the Union. Of course, Mississippi then, within a couple of decades, began to strip all of that out of its state constitution, and now at this point, the Mississippi Education Clause basically says, should the legislature wish, if the moon is full and it feels like it, it can kind of provide education to some people. The language is a little more formal, but it's really not that much better. But the freeness was a common theme in the Reconstruction era, and it had real effect. By the time you get to 1871, you had over 54,000 African-American children attending free public school, which is just remarkable in a place that had considered them chattel within a decade. So providing free education is one of the most transformative choices we've made as a country. But we are continuing to erode the freeness of public education as privatization increases across the country. So just as a couple of core examples. So we tend to think of, and much of federal and state law considers charter schools, for instance, to be public schools. But charter schools are not free the same way that most traditional public schools are free. So we think of free as not requiring tuition, and that is certainly part of being free. But there are all kinds of other, schools are the hearts of our communities, the locus of so many social services, and so much of that is not necessarily obligatory in charter schools, let alone private voucher recipient schools, virtual schools, homeschool, et cetera. For instance, free and reduced meals programs. I'm going to get the stat right. Nationwide, about 40% of public charter schools do not participate in the federal school breakfast and lunch program. That means there are a number of states, including California, that specifically exempt charters from participation in free and reduced meals. That's going to cost families hundreds, if not thousands of dollars a year in providing meals that are supposed to be provided free for your attendance in public elementary and secondary school. Transportation is another really big deal in this context. A huge number of charter schools do not themselves provide transportation. They rely on their local school district to provide transportation. A number of states, including Arizona, Arkansas, Washington, and Wisconsin, their state laws do not require charter schools to provide transportation at all. So again, hundreds, thousands of dollars, significant input from parents to actually access that form of ostensibly free public education. Then there are just really bald-faced obligations for parental contribution. Now, no one requires parental contribution, truly, in public charter schools, although a number of charter chains ask for parental contribution. The Basis Charter chain, which is one of the largest in Arizona, asks for a $1,500 a year contribution to help pay for teacher bonuses. There's another charter, I believe this one is in California, that asks for a $3,000 a year contribution as well. Those are not small amounts of money, and certainly not small when you're talking about a free public education. And that's to say nothing of forced volunteerism. This is a really common theme among charter schools where you are obligated as a family to volunteer your labor, typically about 40 hours, which, for working families is 40 hours of unpaid labor that you are providing, and it has value to your school. There are states such as Florida that actually permit volunteer mandates for public charter schools. So back to forced labor, I guess. So these costs, of course, are, they pale in comparison when you look at charter schools compared to private schools. The average cost of private school tuition in this country is over $10,000. There are almost no voucher programs that provide that amount of money. Typical private school vouchers are between $4,000 and $7,000. There are some places that provide up to $10,000. But that is to say nothing of, for instance, the cost of educating a student with a disability who, under the Individuals with Disabilities Education Act or under Section 504 of the Rehabilitation Act, would receive services that might cost tens of thousands or hundreds of thousands of dollars in the public system. Of course, LEAs and SEAs are obligated to pay what's called a proportionate share of their funds to private schools to educate children with disabilities under federal law, but there is no individual right for children whose parents place them in private school to receive the kind of free, appropriate public education that they receive in public school, and certainly things like getting evaluations, all of the obligations that are quite costly that public schools bear just don't exist in private schools, even though very often in all of our states that provide vouchers to private schools, you are getting some form of public money subsidizing this form of education. So I will conclude on my, my thoughts on the freeness of public education simply with the thought that, you know, we have, as litigators, as scholars, we have focused on many of the other core components of public education, on its thoroughness, its efficiency, its quality, a number of different phrases that you hear throughout state constitutions. But I do think that going back to the freeness of public education is a core aspect that we can't forget. Freeness is what actually made public education accessible to the vast majority of people in this country. Education was accessible, as well as laws against discriminating on the basis of, race and sex and what have you. But freeness was an incredibly important component of that as well. And as we continue to see programs that call themselves public but are not in fact free, or programs that use public money and are not even remotely free, that thinking about challenges in that regard, that's going to be an important avenue, because we have, in many ways, lost the fight with the idea that these programs are public, but the freeness is still an open question. And so for all of you future litigators out there, think about that both here in West Virginia as a means of protecting your state against privatization, and in other states across the country as well.
Thank you, Zoe. And Mark, I had a question for you, but at first I want to just check in to make sure if anyone has a response or wants to comment about what Zoe or Scott or David said before.
Well, again, just in the interest of having a
please,
conversation,
please.
I just want to, I'd rather also talking to each other. I just want to highlight, I think Zoe's points are really powerful, especially, one of the things in thinking about Paulie, and like my colleagues, hadn't read it in a long time till got invited. But, and one of the things, not to take away anything from the power of that decision, but thinking about how the nature of education, public education, broadly speaking, has changed since then, right? So the Paulie court wasn't confronted with the impacts of charter schools or private school vouchers. And so, and just thinking about the issues that Zoe was raising, when one of the, besides the obvious fiscal impacts of those programs and what they take away from the traditional public schooling is, the questions about students with special ed, students with special needs, there's that aspect of the impact of those alternatives, leaving who's left behind in the traditional public schools, typically the hardest students to educate, right? The students with special needs, the students who have experienced the adverse impacts of poverty and come to school, bearing a host of burdens unrelated to their schooling, opportunities for pre-K, opportunities for other socialization. And so, it's not just the funding implications, which is what a lot of people think about when they think about charters and vouchers and how they're taking money away, but also how the substantive change in who's attending the traditional public schools and how that impacts the state's ability to provide. In North Carolina, we call it a sound basic education, an adequate education, a thorough, efficient education that, in some ways, Paulie is this really brilliant, shining example, but it's also important to keep in mind how much the universe of education has changed since then and how it presents a different host of challenges related to funding, of course, but also just related to being able to provide sufficient education.
So I want to pick up on some comments about Paulie, what Paulie didn't do. And I think, Mark, you talked about it, which is the issue of the disparity and a word that I think we also lose sight of, other than free, in these constitutional provisions, is the word system. These are supposed to be systems that the state is obligated to provide a thorough and efficient system of public schools. And so that has enormous implications for the kinds of issues that Zoe is talking about, that we see now, which is the states essentially creating parallel systems of schools that might not be totally free, that are under lots of different standards, can be free from a lot of the requirements that you see in public schools and free public schools, so forth and so on. So that's a really important word that we also don't talk about. And I think the Paulie court was concerned about that. I mean, that was a huge issue with the court, which is this is a system that needs to be available for all West Virginia school children, same way that the Rose Court talked about it in Kentucky. The one point, though, that Mark's point that Paulie sort of, I think, hints at a little bit, but because of the time didn't get to, which was really picked up in Abbott, and cases like Abbott or the Kansas case, and cases that we've seen since, and that we now sort of accept in a lot of the discussion of what education rights should mean, whether it's in court or in the legislature and so forth and so on, which is the notion that poor kids need more. I'm going to just say it simple. And I think that the Abbott court is the best on this, really. The idea that to have a thorough and efficient system of education, the system can't have disparity in educational opportunities, resources, and outcomes for vulnerable groups of students that need more when they come to school. So that notion really was not really developed in Paulie. Mm-hmm. They sort of talked about it when they hinted at the supplemental funding piece. Right. Yep. They said, they were kind of getting at that, mm-hmm. But this is 1979. Fast forward to 1991 when Abbott versus Burke, Abbott 2 comes down. It's a shockwave because Rose was really about the entire system underwater. Abbott was about disparity, what Mark is talking about. A state, New Jersey, in which you had some of the most powerful, highest performing free school systems in the country alongside schools where the state allowed systems that were literally next door, that were falling and crumbling apart, systems that had to educate large numbers of kids who came to school with additional needs. So you get to Abbott, really fills in the gap, which is the system also, from an adequacy or equity, this is where equity and adequacy really kind of come together, which is the system also has to make it, and this is I think a challenge in West Virginia today, and in a lot of states that have had good rulings, but they really haven't grappled with the core issue of what does a state have to do to fulfill its constitutional obligation to make sure that if the state is going to run a system in which poor kids or kids of color are concentrated in huge numbers and high numbers in a subset of schools within that system, what does adequacy look like? Abbott answers that, and cases since that sort of answered that unanswered question in Paulie, and Rose, I would add, really gets to the issue of this notion that if you come to school with additional educational needs, the state has to, and the state is essentially, through its governance mechanism, allowing that to happen. Keep in mind, the question of where you go to school and how district boundaries are drawn, or whether we have charter schools or not, are actions by the state through the legislature in the performance of its constitutional obligation to run the system. So we really have to get our minds around that. So the whole landscape of West Virginia, what it looks like, this system, is a creature of policy. It just didn't happen. Well, there's other things that influenced, obviously, discrimination and housing patterns and all of that. But the decisions of how the school system is set up is a decision that's made by the legislature in the performance of its obligation to run the system. So I just want to make the point that where we we need to make the point that Paulie didn't get at, but sort of laid the groundwork for other courts in New Jersey and Kansas and other places, and now in current litigation, Mark's case in Pennsylvania now that's going forward, Delaware, as if you look at the Delaware complaint that was just filed, this is all about the system not providing the additional resources, the additional supports, the additional interventions that school systems within the state, local school districts within the state, have to provide where they're serving large concentrations of low-income children, children of color, English language learners, and children with disabilities. And that's the sort of real struggle today, I think, in a lot of our fights, is that we have these systems that have evolved in which the state, through its education policies and through other policies, have created local school systems that where the load, I mean, when you think about it, the educational load on the teachers and the schools from having 60, 70, 80, 90% of the children coming through the door coming from households that are below the poverty level, you know, large numbers of kids coming into school who need to learn English in school, kids who are coming from neighborhoods with a lot of problems. What's the question today really that we're grappling with is, how does a state fulfill its constitutional obligation, whether it's through legislation or through a new funding formula, or how does a court approach this in terms of enforcing constitutional rights to make sure that vulnerable populations of students that are the ones that are not getting what they need, get what they need. And that's a sort of hinted at in Paulie. Rose really didn't grapple with it because they just threw the whole thing out. But then you get to Abbott, where it's really about the system having these very disparate allowed to have through its funding mechanism and other policies, essentially school systems that are well-resourced, high-performing. Kids are coming from affluent backgrounds, already have advantages, alongside school systems that are struggling with less resources and great need. That's probably the #1 problem or fundamental structural issue in American public education today that we've got to grapple with.
You know, I'm really glad that you focused on that word system, because I actually think it pulls us back to the first question that Josh asked, which is, what is the nature of education, the right to education? Right. And I think this is where I say the thing that maybe makes me an iconoclast here, and that is, I'm not sure there is a thing that we can refer to as the right to education in the sense that it is a positive individual right. The reason I think that is because state constitutions, with the possible exception of Wyoming's, don't mention anything about rights in their education clauses. They mention duties. What we're generally enforcing in these cases are duties for the legislature to provide for a system-wide, which is why I'm really glad you focused on that word, for a system-wide organization of schools that educate the public. And when we litigate these cases, we generally are challenging something systemic. In Abbott, it was more of systemic inequalities from one district to another. In Rose, it was a systemic inadequacy that resulted in no bathrooms in schools and rats running across the floors and things like that, right? So, when we think of these cases systemically, there's a natural problem that arises, and that is the problem of constitutional conflict between two co-equal branches of government. Now, I started out when I was writing about this stuff thinking that these cases should just never be justiciable because the terms in state constitutions are so malleable and so subjective that how could you possibly hang your hat on any of them, right? And I've come gradually to the position that justiciability is required at some level to make sure that constitutional language isn't a nullity or just auditory or just sitting in the Constitution for no reason. But we wrestle with this problem in every one of these cases about how far a court can go in telling the legislature how to perform its core function of taxing and appropriating money, which is what at bottom this is really all about, taxing and appropriating money. And we're seeing this play out right now with the national emergency crisis, right? How far can the president go in overruling Congress's decision to tax and appropriate money, all right? So these constitutional conflicts are not unique to the school funding area, right? So taking seriously the question of whether there is a right to education, I think there's space for one. I'm just not sure that in any case we've actually recognized one yet. And the reason I say that is because of the way that the cases are formed and the remedies that are ordered. The remedies that are ordered are usually systemic remedies that go to the legislature and do not direct any sort of remediation to any particular plaintiff or any particular group of individual human plaintiffs. Typically it's districts, typically it is directed at the state. So what I've proposed in a recent piece is that maybe we sort of think about these cases differently and potentially solve two problems at the same time, but do a lot of hard work along the way in doing so. We've been doing this stuff for 40, 50 years now, and the system has progressively gotten better in some places and worse in other places. I'm a pervasive defender of the U.S. education system against these nation-at-risk people who think that we're all going to fall into ruin due to the horribleness of our education system. By and large, it's a good system, but there are pockets of it that are very bad, right? So thinking about those pockets where things are bad and taking the idea that a right to education may exist as a correlative to the duty of the legislature to provide an education system, why not litigate these cases individual by individual? This deals with Mark's problem, the problem that Mark identified, that we have problems that exist in our system that at least either didn't exist at the time of Paulie or were not on the radar screen nationally at the time of Paulie. Of course, we had kids with disabilities at the time of Paulie. They weren't on the radar screen the way they are now. Of course, we had people trying to privatize education at the time of Paulie. That goes back to Brown versus Board of Education, but it wasn't on the radar screen in Paulie, right? But we have individuals who are being harmed by these new movements today who are in systems where other individuals are not being harmed by these movements. And it makes the most sense to me to focus on the individuals that are actually being harmed and make those people individual plaintiffs and try to garner individual remedies for those plaintiffs such that we have enough cases at some point where the legislature moves on its own without a constitutionally conflicting order from the Supreme Court to make policy in a certain way. That the legislature recognizes, oh my goodness, there's all these cases out here, all these kids are winning, we need to start doing things differently and change the way that we're funding the system. And I think the other, and I'll say one more thing about that, I think the other potential benefit that can come from that, which is the thing I'm interested in, is the malleability and the subjective character of state constitutional language. Doesn't mean it can't be interpreted, but it does mean that interpreting it in one broad swath in a systemic ruling that says thorough and efficient means this for all time, this list of 8 things, is dangerous because we could be wrong about that. Education policy changes over time. And I think the better way to do that is incrementally the way we develop the jurisprudence on words like due in the Due Process Clause and cruel and unusual punishment in the Eighth Amendment. We do it case by case because those are terms that don't have any sort of obvious objective meaning to them. We have to give them, we've got to give them skin on the bones, and the way you do that is through common law jurisprudence. So anyway, there's my soapbox that that builds from what you all are saying there.
It's interesting that you know, a couple of things in that, just on the building individual cases. So we just had a case, we just lost a case at the North Carolina Supreme Court where we brought a Leandro, a state constitutional education claim, on behalf of students in Halifax County. It's one of the poorest counties in North Carolina, and it has 3 separate school districts for 6,000 kids. 2 are all black, 1 is almost all white. And we brought the suit against the county commissioners. We brought it as they have local funding responsibilities. They also have the power to consolidate the districts. And we lost that case because the Supreme Court said, you sued the wrong person. You should have sued the state.
Should have sued the state.
That these are state, this is a state responsibility, and any change that's going to be made around the constitutional right to sound basic education is going to be made by the state. And it's interesting because when we brought that case initially, we had allies, education advocates, who said, you shouldn't bring this case. We want the state to be responsible. We don't want to have to go and file 100 lawsuits in 100 counties to push this, like what happened during desegregation, right, where you had to bring these cases district by district. And we took the alternative theory and said, no, the facts in this case are so outlandish that this will get, the theory was exactly what you described, Scott. And the court just shut that down. Also, we've been frustrated by the stalling in the Leandro case, which was another reason we wanted to avoid getting caught up in
And
it.
that's another purpose for me suggesting this, because
Right.
we keep going back to the state Supreme Courts for ruling after ruling after ruling, you know?
But David's construction of, I wish is this being taped? Because I'd like to have your laying out the current state of the problem and how we serve, in North Carolina, they call them at-risk students, but this subset of students who have these additional challenges for education, how do they get served, and that it's going to require different levels of funding to serve those students. That's really what the issue is now, but the courts continued, I think, to wrestle with it along this separation of powers. In the Leandro case, the court agreed over and over again that the schools were failing students, that at one point the judge called it academic genocide, what was happening in some of these high poverty districts, but then stopped because of this, which is also forecast in Paulie, this separation of powers idea that if the remedy is really just a financial one, we're limited in what we can do. And I think it points out, one, I think that's a misconstruction of what the court's power is. We can talk more about that. But it also highlights, the truth is, there is a political aspect to this, right? The teacher strikes that we're seeing, which I know the next panel is going to talk about, changed the dynamic, right? Produced more reactions from legislatures in many states than a lot of the legislation has. Certainly in North Carolina. It led to real consideration about at least teacher salaries and teacher funding. And so there is clearly this political component to it that has to play a role alongside the litigation if we're going to transcend this separation of powers, fig leaf that the court continues to hide behind. At least in North Carolina, hid behind for 15 years.
Yeah, please.
I just a quick point. So, in terms of where we are today, sort of to fast forward. So the real issue is the advent of standard. I want to come back to standards-based education because, and this idea, this really modern notion, it's only in the last 20 years that states have prescribed substantive educational standards that all kids have to meet. Think about that. The state, in its performance of its duty to implement, if you will, or run, or provide a system of free, thorough, and efficient public schools, has now legislatively prescribed substantive standards that, and look across any state, and you see in statute and rules and regulations requirements for curriculum requirements. All the things that are in Paulie are now in statute, and even more, right? So assessment systems, disaggregation, performance data, disaggregation of data by racial and socioeconomic subgroups, accountability measures, right? So I think what we have to start thinking about, whether, and this is particularly important in the State House, is the political piece, is that we have to be going back to these legislatures and saying, look, if you prescribe these substantive mandates, whether it's kids have to read, I've seen statutes in South Carolina legislature just put in a whole bill. It's wonderful mandates. The state mandating on local school districts, kids have to read by 3, they have to be literate. All of these things, right? States have, legislatures have gone all in on it. And what I don't think we've done is sort of put this in a constitutional framework when we're in the politics of this. If the state is going to mandate substantive educational standards that all kids must learn, know, and meet in order to be proficient or college and career ready, whatever that standard is, that's the legislature fulfilling its constitutional obligation. And the point of this is they've got an obligation not just to mandate, to provide unfunded mandates. They've got a mandate to provide the funding and resources that are sufficient or adequate to give these school districts and these students to achieve the very standards, substantive standards that the state is prescribing that they meet. That's a constitutional. We don't talk about it in constitutional terms, but we need to. So when you go down to the West Virginia legislature, somebody said that some legislators were dissing Paulie the other day. people need to be standing up and saying, no, look, Paulie's good law. Till the Supreme Court overturns that, that's good law. And what that means is that if the West Virginia legislature is mandating all kinds of substantive requirements that local school districts have to meet, including, you know, what teachers have to meet and what their qualifications should be and so forth and so on, the legislatures have a concomitant obligation, constitutional obligation, to have a financing system that is built on the cost of delivering those standards for all kids, and that includes the additional costs that kids who have additional needs have to have. If we don't come to grips with this, you know, look, Scott's point about when Trump came in, I wrote something about, I was telling Governor Wise about this last night. Trump comes in and you know, people are getting all worked up about what's going to happen to the federal role and all of that. To me, it was, you know, it's always been that way. And my advice was, okay, we're going to have an administration that's not going to do anything. And we've seen it. I mean, I'm overstating it, but they're just checked out. States, it's back to the states now, as it has always been. So my advice is go back to your state and enforce the constitutional right in your state constitution, whether you do it in the courts or you make the case in the legislature. These legislatures have to understand that if they're going to require kids to meet certain academic standards and so forth and so on as a part of the state system, they're performing their constitutional duty fine, but then they can't just turn around and say, we don't care about the money or we're going to cut the education budget. So we have to kind of think more broadly about what does the Paulie mean today in the current constitutional, current context we're in, educational context we're in, and how do we use those constitutional, how do we actualize those so that they're not just decisions in a book, but they're used when we go down to the West Virginia legislature and talk to the committee about their responsibility to make sure, look, if you're saying that kids have to, you know, meet these standards or so forth and so on, or provide this or provide that, you have an obligation to make sure that that your system is delivering the resources that gives teachers and students and schools the ability to actually achieve the very standards that you're mandating they meet.
So we can talk, oh, go ahead, Zoe.
Just very quickly to go back to the individual rights question, just to put on the table, you know, the federal system is not generally good on this front, but it did ring a bell for me about Goss and about the question. So Goss v. Lopez, of course, is the case that holds that depriving children of education without due process of law is a Fifth Amendment problem. And so thinking about individual rights litigation under state constitutions through the lens of Goss is a way to go at this question.
Of course, that just gets us to negative rights, though. And what I think all these folks care about who are litigating these cases is positive rights, right? Rights to receive things from the government rather than rights to prevent the government from taking things away from you, right? So definitely, yes, the negative rights definitely exist, but that's a right that is a right of basically property or liberty. And it's not really a right to education. It's a right to not have your education taken away from you once it's given to you, right? So the thing I'm interested in is, do you have a standalone, freestanding right to education that doesn't depend on somebody taking it away from you, that actually allows you to compel the government to give it to you, right? That's the important question here when we're thinking about whether there is a right to education. Otherwise, there's a right to due process, which is what you're talking about. That's a right to due process, not really a right to education. It just so happens that the property or liberty interest in that case is an education interest. It's not a right to education. You know? So it's not the kind of right to education that I'm referring to when I say that.
But you know, Paulie says, Paulie talks about being free from discrimination and so forth and so on, you know, in West Virginia.
And I don't think there's anything controversial about
that.
No,
but the point, you're making a really good point, both of you, which is around what I was just saying about what's the legislature's constitutional obligations for the system. Obviously, I was talking about money, you know, closing the loop, not just mandating standards, but providing the resources. That's critical. But it also extends to things like discrimination requirements and due process requirements in school discipline, school-to-prison pipeline issues. There's a whole host of issues that we sort of think, oh, these are federal matters. No, these are matters of the right to a thorough and efficient education is defined by Paulie, includes the right to be free from discrimination in the system. how do we operationalize that? How do we get the legislature, let me put it this way, to operationalize that in state statutes and rules that ensure substantive, due process for individual kids, access to services for individual kids, heightened standards of discrimination. Because keep in mind, states can go in this field, because this is a state right.
Sure.
State legislatures, and they do, go far, far beyond what the federal government provides. And I just don't think we around the country have really grasped. One of the things that I go around the country and do a lot of this, it's really hard to, and talk to reporters and all of that. People don't understand these are state systems. We have no national system of education, and we're not going to have one. Sorry, Derek. No. And so how do we get people to understand that that the condition of education in West Virginia, how West Virginia kids are doing, is a responsibility of the state legislature, not Washington or not another state. And how do we deal with states? The problem in our country is, and Zoe has heard me talk about this, our problem in American education is we have some very high-performing state systems. But we have whole regions of the country, states and whole regions of the country, if you want to think about it this way, that are dragging the whole country down academically and educationally, because they're mandating all these standards and they're disinvesting, they're not providing the resources or the individual protections and other things you need to run a high-powered educational system. That's only going to be solved in the State House.
Well, and I just want to say on the individual, North Carolina, the court said that it is an individual right, that every student has the right to a sound basic opportunity for a sound basic education. They didn't identify.
A lot of them use that rhetoric.
Right, they do identify it as an individual right, and then the fight is, what does that mean, right? What is a sound basic education? And you start with the early decisions that say, to be able to read and write in English, to know math, to know social studies, to be able to be a citizen, or to be able to be meaningfully employed. But it is described, at least in those opinions, as an individual positive right.
And that's absolutely right. Yeah.
And so, and then we get into this fight about what does that mean, right? And then what does it mean to provide the opportunity? So I think I think it's there in these opinions, and then the struggle comes with how exactly what David is describing is. And what is, there's been this resistance to sort of making the connection between just funding and and how these opportunities work together, right? So they do have these mandates, right? In North Carolina, a few years ago, they passed this Read to Achieve law. You have to be able to read by 3rd grade, and if you're not, you get held back. And they passed it 4 years ago, and what they found, so that in those 4 years, the number of students who can read in 3rd grade has gone down because the schools have been starved for the resources they need, particularly the schools with the students with the highest needs. And so what we're expecting is not more funding, but that the law is going to get changed this session to soften the requirement, right? So, but I do think that that making that connection between these mandates and then the availability of those resources, and you talked about it, David, as it's not just between districts, right? We see it in North Carolina within districts, right? So you have, because of the legacy of residential segregation, you have, schools schools in West Charlotte are all high poverty, racially isolated, low performing. Schools in North Mecklenburg County are overwhelmingly white, they're upper middle class, and they're high performing. And when Charlotte Mecklenburg School says one of the things we're going to do to start addressing that is we're going to redraw the lines, the towns, the predominantly white towns in North Mecklenburg said, we're going to set up our own charter school systems so we don't have to go through a reassignment. So those are that aspect of that engaged, engagement around the equitable distribution of resources remains powerful and potent and continues to be driven by issues of race and class. That we've got to be able to come to terms with. And the other aspect, and I know someone's waiting to talk, but I just wanted to get this in quickly. It was something, going back to the free stuff that Zoe started with, just to put a zoomed out umbrella over all this. When we're talking about public education, and Nicole Hannah-Jones has talked about this, other folks at the folks at the Haas Institute, John Powell talks about this, is, you know, what's being taken away is the public aspect of public education, right? It's no longer being recognized in large quarters as a public good. And so what we're seeing now is this, with this privatization of education and the marketization, is this idea that the only measure of educational accountability should be parental choice rather than the public interest. And what these cases are about when they talk about a sound basic education or an efficient or a thorough education is talking about maintaining the public good in education. And that, you know, I think when we're going to the legislature and pounding on the desk, one of the things we have to talk about is the, you know, the legislative, you know, support, the legislature putting its, with all these programs by starving the funding resources, is the legislature's putting their imprimatur on people being able to withdraw from the public space. So that's my soapbox.
Well, thank you guys, because this has been fascinating. But you all have touched on various times talking about vulnerable children, vulnerable populations, and also talked about like regions of the country that are bringing things down. I primarily work with the special education program at Legal Aid West Virginia. And one thing we're seeing, especially in our southern coalfields, but given that the majority of you are primarily from the south, I'm sure you're seeing it too, is with the opioid crisis and what it's doing to our school systems. We have counties in the state where more than 50% of children are not being raised in a natural home environment. They're in a kinship care provided environment, and they're coming from some sort of trauma, which of course then increases the likelihood that they have a learning disability or a behavior disorder or a diagnosis of some kind that would qualify them for 2419. And I just wondered what you see when you're talking about individual cases versus systemic and federal and state kind of juxtaposition. Is there, possibly not under the current federal administration, but do you think that there might be this time when these counties and these states get overwhelmed with their special education population and their child find responsibilities, that, you know, there will be a federal suit under IDEA that puts more of a burden on these counties through the state constitutions?
David, I think you're that.
Well, I'll make a
One
quick,
who's most closely
mention of the,
associated with these cases.
we're doing litigation in Flint over this, you know, and we have a class action that we brought against the state of Michigan over the situation in Flint around special education. So you had a district that essentially was falling apart before the lead crisis in terms of the delivery of special education services, its child find responsibilities under IDEA, so forth and so on. Chronically underfunded by the state. You know, huge hole in the special education budget every year, which is something you see structurally in a lot of these state financing systems where special education is, it's mandated by IDEA, gets the resources, and then, you know, the districts have to reallocate within their budgets off the general fund, so forth and so on. You know, so we confronted, what do you do? I think you're asking this question in a broader sense. What do you do in this case, in Flint, when the entire school-age population has been exposed to lead, which is a potential factor contributing to disability? So what does child find do in a kind of systemic, we've never really IDEA never really, when IDEA was, you know, nobody thought about this, right? That you could have a situation where every single child in that community was at risk of, not that they're all gonna, you know, require special education, but is at risk of a disability, and what kind of child find system do we need? I think we've got to start pushing on this in terms of the existing law. I don't think Congress is going to help us out here anytime soon, but there's a lot that you can do. What we wound up doing in Flint was a settlement in which we created essentially a new child find system because we knew the district couldn't handle it. They just didn't have the capacity, the child study teams, the so forth and so on, to just do the child find properly. So we basically engaged the health community in Flint to do it. And so now if you live in Flint and your kid was exposed, you can sign them up online in a registry. There's a screening that goes on. If there looks like you need to get further evaluated, you're referred not to the child study team, but to a center, health center, and then all of those results go back to the school. And we just started this, so stay tuned. I don't know how it's all going to work out. The second part is about trauma. So this gets to something that the Abbott court said. It just, to me, is something we should try to put in our heads. The court was grappling with the question of, that we talked about, what's the, and this is the sort of bedeviling question in school finance, what are the additional resources and what do they cost for kids who are at risk in these high poverty school districts? And we need a lot more research in this area from educational researchers. We know preschool, got to get them in preschool. We don't get them in preschool, they're already behind. So that's something that has to happen in terms of meeting the need. But there is this question we need to do a lot more work on, and I know Zoe and others are looking, which is what are the interventions that high poverty schools, like the ones you're describing, that have a lot of trauma and other things that are happening to kids outside school that affect their schooling, what are the program staff and services that they should be providing, either directly or through collaborations with community-based programs, that will, and this is the way the New Jersey Supreme Court said it in Abbott, that will wipe out the disadvantages that these children bring to school as much as a school can. That's a term of art that research has to, so what we need is assessments of what are the needs of kids in these trauma places that you're talking about. We've got to get the State Department of Education down there to figure out what are the interventions what's the impact of the opioid crisis in these communities on kids' educational opportunities? And what do we need to do with schools to ensure that they have the interventions they need, the staff and the supports they need to address these disadvantages? Because if they don't have them, all it's going to do is, burden the teachers and the principals and so forth dealing with, crisis after crisis. So that's a really important issue that we have to keep pushing on, which is this notion of what can we do in schools? What is reasonable to do, given the fact that unlike other school systems in nations around the world, we don't have a decent social safety net for kids, right? So the schools are left with, unlike in France and other places, they don't have to worry about homelessness and all of these things. We do. Schools have to. So that gets back to the resource question and connecting schools to community and all of that.
Well, here, I know you guys have it in Kentucky, I'm sorry.
Homelessness.
Is, well, not just homelessness, but we have counties where they know a referral needs to be made to the medical community, but there are no providers within a 3-hour.
Right.
And I do want to just note for the record that I agree, David, that asking the school system itself to do much of this is probably not feasible, but we do have an incredibly important law in this space, which is EPSDT. For the folks that mostly do education work, this is the children's component of Medicaid. It stands for Early Periodic Screening, Diagnostic, and Treatment. Why it's diagnostic and not diagnosis, ask someone in Congress. But the EPSDT mandate is, I would say, the single most important underused legal hook in this context. Schools are Medicaid providers. Public schools are Medicaid providers. They can bill and should bill Medicaid. A huge number of schools do not bill Medicaid for any services because they don't have a Medicaid biller, which is an absurd reality that puts, form and administration over access to services, especially because so often you have between a 70-30 federal-state match to a 90-10 federal-state match. So there is an enormous pot of money that is sitting there that is already appropriated for state and local use through the Medicaid system. And so I would say, when it comes to things like diagnosable complex trauma, let alone any other number of qualified disabilities under the Medicaid Act, you do actually have access to an enormous system of services. It's just that actually braiding and blending Medicaid funding into the education system is so rare. I'm truly, I mean, only New Mexico has a statewide effort to do this in the way that you would want to see, and they're still radically underfunded for everything else in education, as the folks litigating that case would tell you. But I will just sort of put a marker to say we don't need a new law saying that kids with the sorts of disabilities or disadvantages that you're talking about have a right to services. We have one, it's just not enforced.
And the Flint Child Fine universal screening and evaluation process, we put it outside of the school system, in the health system, with the connection to the schools, precisely for this reason. So the federal government would pay for it.
We have time for one question.
I'm here to give a ray of hope. This has been fabulous. I have loved hearing this. I came to West Virginia almost 40 years ago about this time, and my children were part of the public school system for a short period of time. And I do special education law, I do all these issues, and you have done such a great job of framing this. And here is the hope, is like you have, I think, correctly identified, is that state legislators have to realize that they have to fund this. And here's the ray of hope. I watched the elections last November, and I see state legislators changing. I see them understanding it. The role that universities can play is helping to have them define, connecting those dots about why not spend this money up here, or you're going to spend $40,000 per person a year in the prison system. I mean, that's a little bit simplistic, but and I see 3 of my former students from University of Louisville in our state legislature, and they're fighting for these issues. And I am hopeful, and Mr. Rogers said, look for the helpers, and I am hopeful that we have helpers. And it's not going to happen overnight, but I think conversations like this really help to move that forward. So thank you very much.
Yes, thank you for ending on that highlight. I want to thank our panelists, of course. Thank you for, this has been an excellent spirited discussion. Can we all give them an applause, please? So I wore my red for Ed tie today in anxious anticipation of our next panel. And as we invite our next panel to join us, I wanted to draw our attention to a short clip here of one of our courageous and inspiring West Virginia teachers.
Pocahontas County is one of the most rural counties east of the Mississippi. It's over 70% state and national forest. There are huge pipeline problems in West Virginia. Right now, around 40% of the classes in grades 7 through 11 are taught by uncertified or undercertified people.
Oh, look at the spells on her now.
So you have to wonder in that setting, are you really providing free and equal education to everybody? If some people are expected to learn mathematics from someone else who doesn't necessarily know mathematics. From the first maybe 2 years, 2 years into teaching math, I really started watching kind of the horizon of how schools do or don't support teachers to get better, and how odd it is that teaching and learning is such a community exercise, but there really isn't community among educators in secondary math. So I'd been kind of building my own change theory for, 8 years or so.
Yes. Don't you think yes? I mean, we're just developing this right now. So don't you guys think yes? It seems that'd be super weird. Yeah.
The 2 main things that I'm up to are either working with individual teachers in their classroom. So I really believe in embedded professional development. So either I'm modeling a lesson that we're trying to work on together, or the teacher is, and either way we're giving each other feedback on the same set of questions. Or I'm organizing and orchestrating teachers to work together.
Architect's direction here, the pre-number 2.
Like if you feel good about this problem, you better claim it as the architect. Like I
so
want to
maybe
be
this actually goes along like
you think everything is fine, and you're on your way to be a teacher now, and you're in charge for the rest of your career in your classroom. And it wasn't so much that I'm not in charge anymore, but it's so nice to have someone to emulate and to look up to. You know, even as a teacher, I still want to be a learner.
Pretty traditional in a coaching model that a coach observes. We try to ensure that at least as often teachers are observing.
Even if what I'm asking you to do feels super awkward today, I want you to just roll with it, okay? And then at the end, we'll talk about what worked, what didn't, and what kind of changes you guys think we should make before we kind of finalize this. Does that sound okay?
Yeah, right, because it's hard to keep track of all that algebra in your head.
So compared to kind of working as a group with no structure at all, what was better about using these roll cards and what was worse?
The math program before Joanna started implementing some of the ideas that she has, we were in rows. We were in rows. Here's the math book. We started chapter 1. A teacher would get up in front. They would lecture. This is how you do the problems, and then the kids would sit and work on problems they're having for homework.
See, when you're in rows, you're kind of in your own bubble. If you do get stuck on a problem, you're kind of scared because you don't want to ask your teacher. Each of you is going to have a problem eventually, and it's slowing down the process.
Okay, so go ahead and start navigators.
Would equal whatever number, and you'd have to divide it by 250. See how many 250?
I truly don't know if I'd still be a teacher today if it wasn't because of Joanna. It's really nice to know that you have someone working so hard and who truly cares about you in your classroom, cares about your kids, but also cares about you as a person and makes sure that you're okay in your job. It's important that teachers are happy in their job so that they continue and want to, you know, spread the love of learning to their kids. I think that's super important, and she certainly spreads the love of learning to all of us as teachers.
That's what you say. You be real. That's fine. We're not judging each other today, okay?
I miss teaching on a daily basis myself, and it would be really cool to think of a new version of teacher that isn't just a teacher, but is this hybrid teacher leader doing the work in their own classroom and then letting us be a little bit creative about how to get them outside that classroom and better network to other people. In so doing, I think we can retain way more really motivated and driven people in the profession of teaching and also allow them to grow one another as they learn.
That better? Yeah. Hi, I am very happy to be here. I'm Susan DeJarnett from Temple, and I'm especially excited to be on this panel, which is reflections on the teacher strikes, which of course have, we can hardly keep up. There's a new one every day. I think this panel is also going to be really interesting because I'm the only law person on it. We're going to get a broader viewpoint than sometimes we get in these things, although it's going to be a tough act to follow that first panel. So I want to quickly introduce our panelists, and then we're going to do something a little bit different, which is, well, I'll explain in a minute. On the far end is Dr. John Hale, an associate professor of educational history at the University of South Carolina. John's research has focused on the history of student and teacher activism, so very apropos for this panel, grassroots educational programs during the Black freedom struggle, and the segregationist origins of school choice, a point very close to my heart and scholarship. His award-winning book, The Freedom Schools, A History of Student Activists on the Front Lines of the Mississippi Civil Rights Movement, examines the role of youth activism in the civil rights movement. And he's currently working on 2 book projects on the history of Southern Black high school student activism and the history of the school choice movement since desegregation. Jennifer, in the middle, Jennifer Berkshire, I've been a fan of for a while. She, among other things, has the Have You Heard podcast, which for anyone remotely interested in issues of public education today is a must. You must listen to Have You Heard, which Jennifer does with Jack Schneider, who is an education historian at Holy Cross, right?
UMass Lowell now.
UMass, sorry. It's in Boston, what can I say? They are just finishing a book called The Dismantlers about the privatization of public education and it's how it's flooding out in all directions, I guess, if that's fair. Jennifer is an expert. She's a freelance journalist, among other things, and she's going to interview our panelists. So rather than me ask questions, I get to turn that over to her. Finally, we have Dr. Erin McHenry-Sorber, who is a professor of higher education and senior scholar here at West Virginia University Center for the Future of Land-Grant Education. Her research focuses on rural schools and communities with an emphasis on leadership and policy. She's authored publications on rural community teacher strikes, the influence of fracking on the work of rural leaders and on low-income women, critical place conscious leadership and multi-district leadership, and is currently working on several projects, including rural leadership in times of crisis, the West Virginia teacher shortage, and the West Virginia teacher work stoppage. And with that, I want Jennifer to reflect, who's really been following these nationally, to give us some reflections and then lead us through the interviews.
Sure. Well, thank you so much, and I'm so pleased to be here. I do not have a background in law, so I feel a little bit intimidated after that last panel, but I will do my best. So this past week, when the West Virginia teachers suddenly went on strike again, I found myself in the same situation that I imagine a lot of you were in, desperately searching for information about what was going on. And I found myself not particularly happy with the kind of coverage that they were getting, right? That there was something about an omnibus education bill. I heard that the teachers thought it was retaliatory again for the last strike. There was something about charters and vouchers. So I went looking, and I found a piece that Josh Weishart wrote, and I thought that it was just incredibly smart, and I actually wrote a little bit down about it. And he said that, people were missing some really key and fundamental things about what was happening in West Virginia. One was that there was this sneaky bit in the bill that would have shifted the obligation for funding of some of the schools back onto the counties, and I never saw that mentioned anywhere. But at the heart of what was happening was really this question of liberty, and that the advocates for breaking up the system will argue again and again that they have to protect students and parents from the state. And he argued, Josh made the case that actually they have that totally wrong, that the state responsibility to provide education is a positive liberty. That's what gives students, makes them citizens. And I thought, this is such a powerful explanation of what's happening. And then I thought, well, gosh, it's going to be really hard to pass this off as my own insight with Josh right in the room. So check out Josh's post because it was really smart. So I've been asked to give an overview of what's been going on with the walkouts. And what I really want to do is try to draw the connecting thread between the first round of walkouts and the ones that are more recent. Because the argument that we're hearing a lot of in the press is that there was a round one, which started here in West Virginia and then proceeded on to states like Oklahoma and Arizona. And basically, those were about bread and butter issues. Those were states that had disinvested from public education, and so teachers had no choice but to walk out and shut their schools down. And it's really true, right, that you got to see for yourself the impact of austerity. And it wasn't hard to find people who lead policy in those states actually making, fairly blunt statements that they're not so sure that the state should provide public education anymore. You didn't have to pick up many rocks in places like Oklahoma and Arizona to hear people saying that, we've tried it, but now it's time to do something else. And in Arizona, I think you really saw the clearest example of this, where for a time you were going to have two competing ballot initiatives One was for universal version of what we saw proposed in West Virginia this week. These are these education savings accounts. In Arizona, they take the form of edu-debit cards, right? So some portion of the state per pupil funding gets loaded onto a debit card, and parents can spend it on virtually anything they want. It could go to homeschool, it could go to a course, it could go to therapy. They get to decide because it's the parents' right to decide that. And then the teachers brought a competing measure called Invest in Ed that proposed taxing the wealthy at a higher rate in order to fund public education. Unfortunately, the Supreme Court, newly stacked by conservative appointees, threw that out. And then the voucher measure did go to the ballot, and it was voted down overwhelmingly. When people are given the option to weigh in, and it's not just a backroom deal over and over again, the public says, we still believe in public education. So these round one walkouts were about very fundamental questions about teacher pay and about funding for public education. And then we get into the next round, which we're in the thick of right now. So we saw LA, we saw Denver, and as of yesterday, we saw Oakland. And what you hear in the press is that, well, these are still about teacher pay. They're still about fairly bread and butter issues like class size. They're still about school funding. But there's something more fundamental at stake in these strikes as well that I don't think you're hearing enough about, and it very much relates to what we heard our last panel talking about. All three of these cities, Denver, Los Angeles, and Oakland, are very much in the throes of an experiment that now, dates back, really the idea dates back to the Clinton era. And this is this idea that, the government can fund schools, but it really doesn't need to run schools. And, we heard a lot about the school system in the last panel, and the argument here is that, well, you know what, we've tried that. And a school system doesn't really work. So instead, what we're going to do is we're going to have a system of schools. And it doesn't really matter who runs the schools, right? As long as they're able to produce the goods. And so in all three of these cities, you now have 30% of kids in charters in LA, 40% in Denver, 30% and rising in Oakland. And so you have basically two competing systems, and I think what does not come through in the press coverage is that the people who run the systems are they're essentially tasked with the job of unwinding the system. And so you would hear that, like, wow, LA's got a lot of charter schools. It's got 250 charter schools. But you never heard that it's actually the school board that authorizes those charter schools. So you're in this weird situation where the structure that oversees these systems is tasked with creating competition for its own schools that then cause the budgetary problems that the teachers are protesting against. So yes, the teachers were very much demanding things like higher pay. In Denver, they were protesting against a very complex system of compensation that's meant to sort of spur them on to be better. But they are, as their numbers dwindle, they are really the last organized force demanding that these school districts remain public. And if you listen closely, you hear something that I think is a little disturbing, and that is that the people who are in these blue cities, the advocates for this brand of education reform, use a lot of language that sounds like the legislators in West Virginia who were so intent on introducing new charter schools and a new voucher program. They argue that the money should follow the child. They argue that it doesn't matter what kind of school it is, as long as the parent, chooses it. And those are really the fundamental things. And that any notion of, you never hear the words that we heard about in the last panel, the words like free, the words like thorough and efficient, and instead, you end up with these two competing school systems. So I want you to think about that as we talk to our other panelists today. You probably remember that a few years ago, the NAACP passed a moratorium on charter schools. It got a lot of attention. It was very controversial because people who are very devoted to charter schools felt strongly that this was a terrible thing for the NAACP to do. They suspected very strongly that the NAACP had been bought off by teacher unions. And as a result, because the conversation was so overheated, there was a really interesting argument in that decision that got missed. And the NAACP was arguing, among other things, that privatization in many ways lets the state off the hook for its responsibility for educating poor, and especially poor and minority children. And so why in states that have had to fight so hard to get, in places that have had to push so hard to get the state to produce that, why would you let them off the hook? And so you've seen in other states where there haven't been strikes yet, that this debate is playing out very much in the open. So in places like Georgia and Florida, where you had candidates who nearly won governor, Stacey Abrams and Gillum in Florida, ran very much as pro-public education, pro-investment in public education, pro-state responsibility in education. Now, tragically, this is where we get to the sad part of our story. Neither of those candidates lost, and so I'm going to conclude my remarks by taking us to Florida, where it's very unlikely that there will be a teacher strike. I think we're going to hear today that there are lots of places to keep an eye on. Florida, sadly, is probably not one of them. They have all sorts of strict prohibitions. Teachers who strike can lose their certification, they can lose their pension. They have a new law that requires teacher unions to recertify every year. That's likely to knock out some of the larger teacher unions in Florida, including in Miami. So, as I mentioned, the pro-public education candidate lost. It was a very close election. And as a result, Florida is very likely the next state we'll see that's going to go all in for what they're calling universal school choice. And last week, the new governor, Ron DeSantis, made an interesting statement. He said, what makes education public is that it's funded by the taxpayer. It doesn't matter where that money goes. It doesn't matter if it's a district school, if it's a magnet school. It doesn't matter if it's a public charter school. It doesn't matter if it's a virtual school. It doesn't matter if students are getting a tax credit scholarship where corporations donate to a fund. They get a write-off, and then that money goes to pay the cost of tuition at a private, overwhelmingly religious school. And it doesn't matter if it's an education savings account that a parent gets to use to buy homeschooling supplies. It doesn't matter. What makes it public is that taxpayers are funding it. And as education legal scholars, I think people will be very interested to know that choice advocates in Florida are obsessed with that pesky clause in the Constitution. It drives them crazy. They are fixated on how they can get rid of the language about thorough and efficient, about a uniform system. And one thing that I worry about a lot is that I see them using that word uniformity against advocates of public education, that they argue that basically it's just another word for our one-size-fits-all factory model. And so these are, walkouts are incredibly inspiring, and they're making some real progress. They're forcing that debate about what it means to be public. But man, there is also a lot of really scary stuff going on. So we have somebody who followed the West Virginia strike, both strikes, very closely. So I want to start with Aaron. And Aaron, it's just about exactly a year to the date that all the West Virginia teachers walked out, and actually it was a few weeks before that that the Mingo County teachers got it started with something called Fed Up Fridays. And they got the ball rolling, and we're still feeling the implication of that. As someone who is here and on the ground, I wondered if you could just start by telling us what you think was really exciting about the West Virginia walkout and what we might have missed following it from elsewhere.
Thank you. So I think that outsiders have this misconceived notion that West Virginia is a wholly red state. And they miss this really strong, rich history of labor in the state and labor activism, right? Which goes back to the sort of these mythic tales of United Mine Workers involved in these really violent clashes with mining corporations led by Mother Jones, right? And so we have this strong labor history around mining, and we also do around education. This isn't the first major strike in the state of West Virginia. 1990 marked another almost statewide strike in West Virginia, which followed a largely successful miners' strike, and in which miners picketed alongside teachers in support. And so this time around, we see again teachers rising up in protest, first around issues of pay and a very broken statewide insurance system, and sparked by these southern coalfield school districts where we still have this really huge tradition of strong labor. Something that I think is important to consider is the role of women in leading these movements. So in this period of time where women are leading mass protests around a whole host of issues across the country, we see women really leading this movement in West Virginia. So at the county level, the majority of union leaders in the state are women. And we can contrast that to the state legislature, which is ranked 48th in the nation in the percentage of women sitting in the legislature. So we have this picture of this female-dominated profession protesting against a male-dominated, white male-dominated legislature. This is also important in West Virginia because the state ranks last in the percentage of women who have bachelor's degrees, right? It's around 19%. So we're ranked 51st behind all 50 states and the District of Columbia. That has some really big implications for the teaching profession itself in the state, which is comprised of about 75% women. So it's affecting our teaching pipeline. At the same time that teachers are feeling quite dissatisfied with the status of their profession in terms of pay and in terms of the respect they feel they're getting, particularly from the legislature, particularly from some of the Senate leaders in the state legislature. And so we have this mass shortage in the state, which comprises about 4% of the teaching profession, though that's a little low because of the way we report those numbers. We have some districts, for example, that have one certified math teacher for an entire county. We have other districts that have listed every single subject area as a critical shortage area for their district. And so teachers have been expressing their displeasure with the profession for quite some time. They're walking off the job in large numbers with high attrition rates and really low numbers of people interested in the profession. So we shouldn't really be surprised, right, that teachers have finally said enough is enough. We're going to walk off the job. And if we think about those two ideas in tandem, the teacher shortage, in a strange way, almost empowers teachers to engage in these mass protests because they have nothing to lose, right? The state can offer any retaliatory measure it wants, revoking certification or legal action. There's nobody waiting in the wings to take these teaching positions. So I think these are all really important keys to thinking about the debate. And also I think we can make connections to this idea of the public good. In a state like West Virginia, which is predominantly populated by rural schools and school systems, we know that rural schools serve as the heart and the social hub of a community. And so teachers that I've talked to have really felt through the first mass protest and through this most recent one that there's been an attack on the sustainability of these community public institutions, and they really argue that they're fighting for the viability of these public schools, which in turn means they're fighting for the viability of the communities they serve.
That's great. So we're going to come back to West Virginia, but John, I want to move on to you because you are an historian, and so you bring a different lens to this. There was a lot of attention paid to the fact that the early walkouts were in states where unions were the weakest, especially as it was happening right around the Supreme Court's Janet's decision, which was really supposed to, really took aim at states like Massachusetts, where I live, where unions are very strong. So you point out, you wrote a great paper, and you point out that one of the other common themes that drew these states together was that they had a rich tradition of African-American teacher organizing that really hasn't been acknowledged. And I'm imagining that a number of us here today don't know about that. So can you start by going back and filling us in on what we've been missing?
Yeah, so, and I'd love to, because I think it's a point that's overlooked in the southern, especially southern right-to-work states that are organizing, is that teacher organization, in addition to being led by women, this goes back to Margaret Haley's tradition in Chicago and the origins of teacher unions, right? There's another tradition in the South, and we don't hear a lot about the South because they're not going on strike, but South Carolina is currently organizing. North Carolina organized, it was a walkout, a one-day walkout, or I think a call-in or a sick-in or something like that last spring, and that's a lot in the South. That's generating a lot of attention in South Carolina that these teachers are even that organized, right? And that draws on a larger Black organizing tradition in the South. And I think it's largely missed, not just by the press or various opinion pieces out there right now, but actually by the teachers themselves. And one, I'm not surprised, because in South Carolina, in other southern and deep southern states, they have higher than national average white teachers in the teaching force. So South Carolina is about 87% white. I think the national average is about 82% white. And I think they're largely missing the tradition that they're acting in, which is a Black organizing tradition. And you even see this in West Virginia. So when we look, to build upon what Zoe is talking about in the first panel, the public education in the South is a Black freed person's concept. They wrote this into law. And after this is written into law, and after public or free schools are constructed in the South, Black teachers form Black teacher associations to protect that right to education. So Black teacher associations are immediately politicized, and you can see this in their teacher meeting minutes, in their journals. They're contacting local school district officials. They're protecting that right to an education. They're constantly petitioning for greater resources. One of the greatest examples of this at the turn of the century is a Black woman like Septima Clark working with the NAACP and also a member of the Black Teacher Association, overturning these laws that actually say white teachers must teach in African American schools. Every major southern city had these laws until 1919, when Charleston, South Carolina is the last major southern city to overturn it. Black teachers are behind that organization, and Black teachers are working with the NAACP to overturn these laws. So after 1919, Black teachers teach in Black schools. That wasn't always the case. And then in the 1920s and 30s, we have Black teacher associations petitioning state legislators as well as their local district officials to teach, what Carter G. Woodson's talking about, Negro History Week, but also the Black curriculum. And they're at the front lines of trying to incorporate Black history, literature, and culture into the curriculum, which is a political act in the Jim Crow South. And then you get to the 1940s, and we have Black teachers on the front lines of a growing civil rights movement around the teacher salary equalization cases. So teachers in the South advocating for higher salaries and raises is nothing new, especially in the Black organizing tradition. We see Black teachers using the Black teacher associations to do this. And then let's just allow me to skip the Brown decision for a second. But what's left of the Black teacher associations after the Brown decisions, they're at the front lines trying to defend what's left of the Black teaching profession. The most conservative estimates within the first 10 years after the Brown decision that 38,000 black teachers lost their jobs. That doesn't account for the tens of thousands who just voluntarily left the profession, and it doesn't account for the tens of thousands of black teachers who chose not to go into education because there are other career paths open. So we have black teacher associations leading this struggle. So when we dismiss wholesale tens of thousands of black teachers, now it appears to be a white teachers movement. And I say that not to give credit to Black history because it's Black History Month, of course, the shortest month of the year, but because we see so many issues that white teachers aren't talking about. And again, to reference the panel this morning, but the school-to-prison pipeline was a burning issue in the South, especially South Carolina, but we don't hear white teachers talking about that. In fact, we hear white teachers asking for more discipline and sometimes supporting our more school resource officers in the schools. We don't hear about a lack of black teachers, even though there's resounding research that we're seeing again and again that even one teacher of color can have a tremendous positive impact. So not only are we missing some issues because of not seeing this larger black organizing tradition, we're also missing an opportunity for coalition building. And here I'll also point to Dr. Weishart's essay on the 2018 walkouts in West Virginia, is that where he writes, you know, if we don't, it's gonna take more than lawsuits and court decisions and judicial action for true change. And that's something that NAACP knew, that's something that black teacher associations knew, that if it's just lawyers in the courtroom and if it's just teachers, you may not get very far. NAACP, in my reading of the law, or not reading of the law, but rather my reading of legal history, they wouldn't go into a courtroom if they didn't have community support, if they didn't have parents on board, if they didn't have student organizations such as the NAACP Youth Council behind them. Which is why, you know, if you read Federal Judge Richard Gergel's book, Unexampled Courage, where he writes about the Briggs decision in South Carolina, Thurgood Marshall says, you know, we have this won, when he realized that the community showed up and was lining up outside the door in Charleston to hear this case, that they had this case won. They had the community support. So it seems as if we paid attention to this black organizing tradition a little bit more at this moment in time, we see opportunities for broader issues and for stronger coalition building.
Excellent. And we're going to come back and hear some more about the role that Right to Work played in all of that, because it is with us once more.
Yes.
So, Susan, you are in a city, Philadelphia, where there has not yet been a walkout, but the financial issues that have been so key in places like Oakland and Denver and LA are huge in Philadelphia, and you write extensively about the problem of a district that now has to fund two competing school systems. And I wondered if you would just fill us in a little bit about that. And then I'm gonna ask a quick little follow-up question. You told me last night that you sense that the growing frustration among rural school districts towards the idea that they too must pay for competing school systems now via the cyber charter sector, that's a possible way to form a coalition along the lines of what John was just talking about.
I think that's true. I often think people don't realize, and when you say two systems, I would actually say Philadelphia has 86 systems of public education at this point. That's a bit of an exaggeration because a fair number of our charters are part of chains. So it's probably more like 50 systems of public education, because we have the Philadelphia School District, we have somewhere around 84 charter schools that they come and go sometimes. That doesn't count the 12, I think it's 12 at this point, cyber schools in Pennsylvania that draw kids from all over the state, so that's 12 more systems. But Pennsylvania spent, and unfortunately you're always behind the times and the numbers, in the 2016-2017 school year, so a couple of years ago, the school districts across Pennsylvania sent charters 1.7 billion with a B dollars. Because the way Pennsylvania funds charters is that kid with the backpack, like when a kid leaves to a charter, the per pupil funding goes with that kid. In Philadelphia, that meant close to $1 billion all by itself. I'm exaggerating a little bit, it was 900 million. It's a lot of money, and when that money comes out of the school district, the costs don't come down in compensation, which is a whole thing I'd be happy to talk to anybody about aside from this panel. But the cyber schools, I think, are largely driving the potential coalition between rural. Pennsylvania is sometimes described as Alabama with Pittsburgh and Philadelphia on either side, and that's kind of accurate. It's a largely rural state, except for those two big cities. And the rural school districts are incredibly poorly funded. They're very involved in the William Penn funding litigation that David mentioned earlier. So a very conservative Republican legislator from one of those districts is advocating that where a school district is offering its own cyber option, then kids who want to go to the existing cyber charters should pay tuition. And that will be really interesting to see what happens from that. I don't know if it will win, but it's an interesting development.
Erin, I want to ask you about there was some fascinating polling data that came out this week. A young political scientist at Columbia has been surveying people in all of the walkout states. And what was so interesting was that not only did they find that support for the teachers crossed partisan lines, but that support for the teachers predicted support for future walkouts. That they found that people they're saying that, yeah, we support the teachers and we'll support them again. And this led the political scientists to conclude that the walkouts are actually, you're starting to see them build on one another. One of the things that they found that was so interesting was that the more people got information from the grassroots, the more likely they were to support the teachers. And one way of thinking about this is that the weaker the union structure was, right, the less likely they were to have talking points and an official going to a podium, the more likely they were to rally behind that strike. So as you know, I'm curious about how you see this in the context of that women's organizing that's been happening here, and really, you know, we're seeing that not just in as it relates to teacher walkouts, but we're in the midst of a massive women-led protest movement.
Yeah, I would agree, and certainly that's the case in West Virginia, which also has a pretty large women-led eco-justice activist movement, some national award-winning eco-activists in the state, and I think that the grassroots movement is an important one to take hold of. So we see women's activist chapter organizations opening up around other issues all around the state, which is pretty impressive. And we see, specific to the teachers, some real grassroots organizing with the help of social media. And so the teachers unions and the service personnel unions in tandem can very quickly organize a walkout in ways that they hadn't been able to in previous generations of teacher protests. And what's fascinating about this grassroots effort is that in last year's strike, there was a moment where the state leadership said, okay, let's have a cooling off period and return to the classrooms. And at the grassroots level, the teachers said, no, thank you. We're going to stay out on the picket line. So defying that state leadership structure and moving forward at a grassroots or wildcat level to continue their strike efforts. And there was some question in this most recent strike about whether the public would continue to support its teachers, and it really has. And the teachers have done, I think, some really impressive things to continue to garner that support. So, for example, over half of the schools in West Virginia are school-wide Title I designated schools, so a very large high-poverty population. And so the teachers, in collaboration with other community organizations, are serving lunches to students in parks or other community buildings during walkouts because they know that children might go hungry otherwise. And so they've really been able to craft a narrative around which these protests are not about bread and butter, union issues, but are about the education of the state's children. And that if you really care about the education of the state's children, you should be in support of these teacher protests, because that's what they're all about. And I think that we should wait and see if the teachers in this state will walk out again, because the union leadership has authorization from those county unions to strike again at any point in time in this legislative session. And that's quite possible, right? Because the teachers have a real distrust of the legislature and its ability to pass through clean legislation without some of these privatization efforts.
I have a quick follow-up question before we turn back to John and the history of right to work. You drew a very stark picture of the disparity between the women-run organizations and the female composition of the teaching force on the ground versus the people who are in the legislature here. And we really got to see that this week, right? Now, one of the knocks against the teacher walkout so far is that in all the states, they really have not yet produced big electoral change, that you saw people rushing to run in places like Oklahoma, but a lot of them lost. So I'm wondering if you can fill us in on that part of it. How long are the gentlemen that we heard so much from this week in Charleston, how long are they going to be secure in those positions?
That's a really good question. I wish I could predict that. I think that we would be remiss if we didn't consider the large financial backing that some of these long-term legislators have. So we saw come out in this most recent teachers' strike ideas about the role of the Koch brothers through American Prosperity West Virginia and the American Legislative Exchange Council really having a hand in developing and pushing through this legislation. And so we see some real outside corporate interests influencing at least the work of the legislature. And that's difficult to go up against as a grassroots campaign. And so I don't know. I don't know the answer to that. I can tell you what the unions would say and would hope, but we'll have to see.
Well, John, some of those same gentlemen who we just heard Aaron mention have, one of their fondest loves is right to work. It turns out that they have been passionately advocating for this in some form or another, going back decades. And you had some really interesting history in your paper that I didn't know about, and I thought it would be great if you could sort of fill us in on that, how right to work affected organizing, because now we're obviously in a position where the entire country is right to work.
Nearly.
Nearly.
Right. And then also, I think when we look at the teacher strikes, it's important to remember what happened in Wisconsin and Michigan, and that they broke these unions, these historically strong unions that define the teaching profession. But I just want to look at, I think, right to work from, again, a Southern context or within the context of Red for Ed right now.
And can you define it for us, for people who might not know what we're talking about?
Yeah, and I'll say I'll do my best. And this is going through.
Notice why I handed it over to
you.
you.
Yeah, thank you. Yeah, blame it on me, or all the lawyers in the room will come to me when I define this incorrectly. But this is my understanding, especially through labor history. So I'll go back to the Taft-Hartley Act of 1947 as sort of outlining the sort of premise of this. And this will be sort of three parts, and the first of which it bars a closed shop. And a closed shop union will mandate union membership as a condition of employment. So, a district can't say you have to be a member of the AFT in order to work in this school district. It also bars a secondary or a sympathetic boycott, so a company can't go on boycott or go on strike or enact some sort of boycott in sympathy of a southern state, for instance, who's demanding higher wages. So you can no longer engage in these sympathetic, if you will, boycotts or strikes. And third, then there's Section 14B, which is important, which passes further prohibitions on union organizing, which basically puts a bar on union shop arrangements. So this is after you sign the contract. A union is not allowed to force or coerce an employee to join a union. So you have a right to work in this environment without having to join a union. In a lot of pro-union states, for instance, like in Wisconsin before Scott Walker ruined the state, you know, when I was signed a contract to teach in Wisconsin, I was quickly approached and say, okay, now you're going to join this union. I was okay, I understand, right? So it sort of clamps down on that. But I say this because this is incredibly important to the South and the post-war development of the New South, which is the fastest, you know, to look at Nelson Lichtenstein's work in this area. It's the fastest growing part of the economy in the United States post-war. There's a post-war boom in the South. The military is investing in the South. A lot of companies are moving down south. And when you just travel across 26 in South Carolina, it's evidence of this. We see Boeing there, and they move from Washington, right, a union-friendly state, to go to South Carolina. Volvo is building a plant in North Charleston. BMW is in South Carolina. Businesses and Republicans love the South because of this right-to-work legislation. And after Taft-Hartley, it also puts it at the local level. So local governments, county governments, school districts can pass further legislation to say, we will specifically not negotiate with the SCEA, or we will not negotiate with the AFT when we're talking about teacher contracts. So there's all this legislation that only increases business development in the South. And why does this matter? It's because when the nation is experiencing public sector unionism in the North, so here we can look at Al Shanker in New York, we can see within a 5-year span, over 90% of those public school teachers join a union. In the city of Chicago, that's closer to 80%. In 1968-1969 school year, across the country, there's over 230 strikes, and there's over collectively 2.2 million school days in one school year that are idle days, that teachers are walking off. So the South is looking at this, and they're terrified. And at the same time, the SCEA, South Carolina Education Association, they're demonstrating. Now, these are Southern demonstrations, so there's about 300 people in Charleston, 150 in Columbia, but that's enough to make statewide news. So as New York teachers are going on strike, as Chicago teachers are going on strike, South Carolina educators are marching on the State House, and they're after work, they're having a demonstration or rally. So Strom Thurmond and other former Dixiecrat, now new Republican senators and legislators are drawing upon this right-to-work legislation and pushing local school districts to pass anti-union laws saying, do not allow these teachers to follow the work of the AFT and also the NEA, which is now entering in collective bargaining arrangements in the North. So in the South, they draw upon this legislation at a moment that public sector unionism is on the rise to make sure that Southern states aren't going to unionize. So they win that fight. But at the same time, which is interesting, and I try to make this clear in the article, is as the state is drawing on this right-to-work legislation, largely white teachers themselves are following the lead of the state legislators, and they're forming their own teacher associations, which were just merged. So the NEA orders all state teacher associations across the South to merge. So black and white teacher associations have to form one, which are largely affiliated with the NEA. Well, beginning in 1974, nearly all the southern states begin to form anti-union unions, essentially. In South Carolina, it's the Palmetto State Teacher Association. In Mississippi, it's the Mississippi Educators Association. Utah has one, across the South in all these right-to-work states. And they basically, if you read their teacher association philosophies, the first or second line is always going to be, we do not believe in strikes. This is selfish of teachers. We believe in putting children first. Now to connect to what's going on now, most of these states in the South that are organizing under the Red for Ed banner are coming from these anti-union associations. So they're acting like a union, but embracing these anti-union philosophies. So I think which is actually inhibiting this movement in the South as well. So right to work inhibits unionization, long story short. But at the same time, the teachers themselves are actually embracing the rhetoric and policies behind right to work legislation. So they don't want to pay fees. The last resort is going on strike. So at the end of the day, I think that is further prohibiting this coalition development, which is someone like Reverend Barber is calling for at this very moment to really strengthen this Red for Ed movement.
That was very well done. Okay. Thank you. I want to relate that back to one of the recent walkouts in Denver. Colorado was already a right-to-work state before Janus, and I was talking about the theory of change that's really driving the reinvention of these urban districts. And part of the thinking is that unions are, well, they're bad. You can't drive continuous improvement in schools when you have unions. And so in places like Denver, part of the reason that they've expanded charter schools so aggressively is that the charters are non-union, but then they also have a third variety of school called an innovation school. And one of these will be coming to a city near you soon, I promise. And these are basically autonomous schools that are under the auspices of the school district, but run by an outside operator. And one of the autonomies that school leaders and teachers are given is the freedom to opt out of the union. And so as a result, when Denver teachers went on strike, you may have noticed that, whereas 30-some thousand teachers struck in Los Angeles, the number of teachers who actually walked off the job in Denver was only 2,100. And that's because they have an enormous chunk of teachers who teach in the schools but do not consider themselves members of the union. Now, what happened there that was really interesting was that you had a whole flood of teachers who decided to join the union when they heard about a strike, right? That they too have been following the walkouts from state to state. And so I'm not sure that the theory of change is going to unfold quite as sort of cohesively as the visionaries think. That once teachers see that they can actually make some demands and win, that's going to look a little bit different. Susan, I want to ask you to go back to Philadelphia for a minute. Philadelphia was in that huge wave of strikes in the 60s that John alluded to, and they were strikes that proved to be very divisive at a time when cities were facing all sorts of fiscal problems, when white residents were fleeing, the tax base was shrinking. The teachers were really perceived as demanding, being out for themselves, and that legacy lives on. Philadelphia is a place where teachers have really tried to expand that narrative and paint a bigger picture about what it means to be a public school teacher. Could you just talk a little bit about that?
I'll try.
And I'm sorry to spring that on you.
Yes, she didn't warn me. But this is something I think about a lot, and I hope this is responsive. One of my areas of scholarship is sort of the rhetoric of the reform movement. And I think one of the things, I'm curious particularly to hear from Aaron on this, that teachers in Philadelphia at least, and that I read about, are responding to is the vilification of teachers that's been going on for quite a while now, that they're selfish, they're only in it for themselves, they don't care about the kids, the privatization people are the only ones who care about the kids. And I think that history of strikes before, which were primarily bread and butter, fed that narrative more than they necessarily should have. It wasn't very nuanced. But at least now, most of the strikes that I have read about and the rhetoric from the teachers in Philadelphia is much more community-oriented. It is much more coming back at that rhetoric and saying, you know, we are here to preserve public education in the community we live in too, which I think is a very different message. I shared with everybody on the panel an op-ed that two of the lead privatizers in Philadelphia, this was their reaction to the teacher strikes, which the headline is, Teacher strikes a blow against good schools. And first it trashes the teachers for daring to want pensions, like that's a bad thing. I mean, we're supposed to save for retirement. But the most interesting thing in here, I think, is that it's time for the folks who are not benefiting from their educational system to steal the draining resource play from the union playbook. Districts that continue to fund failing schools actually drain resources from desirable charter schools desperately wanted by parents. This is rhetoric I hear all the time because charters are always portrayed as what parents want. And any parents, including me, because I was a Philadelphia public school parent for a long, long time, who want public schools are portrayed as deluded and people who are not worthy of listening to. So that community connection that I think the teachers' unions are finally and a little belatedly building on, I think is really important. Did that even remotely respond?
Do you want to follow up?
Yeah, I would agree. Some of my previous strike research was in a small rural district in Pennsylvania. And so Pennsylvania is different from West Virginia in that teachers negotiate with the district instead of the state. And in this community, you know, the teacher strike was a real disaster for teachers. They were really kind of cast as greedy outsiders who were out to destroy the district. There was a sign in a storefront window that said, "Make my day, shoot a teacher." And so it's just a reminder, I think, that we talk about these strikes as just, these are things teachers can do, but they're very risky ventures for teachers because public opinion can go into very oppositional directions. And I think you're right that teachers have become much better at crafting the narrative around what's best for children. And it's a pretty easy narrative to craft when we see teachers holding up, you know, obsolete textbooks or, you know, they don't have pencils in the classroom. That should be cause for alarm. And that's not a new thing that teachers are dealing with. It's just that they are just now incorporating that or making that the centerpiece of their protests.
I want to do a lightning round so that we still have some time to have questions from the audience if people are interested. So I'm curious, as you know, we're all sort of obsessively following this stuff. John, let's start with you. I'm curious about, one, if anything's going to happen in South Carolina, and two, if you want to make a bold prediction about what's going to happen in the year ahead vis-a-vis the walkouts.
That's tough. Maybe what's going to happen? I'll start. Yeah. I think with South Carolina or across those, I think we're going to see people introducing more and more privatization legislation. I think that so many Americans and even parents see, you know, charter schools, voucher programs, these new education savings accounts are going, this is a silver bullet. This is the panacea that we've been waiting for, that this is the cure-all. I think we're going to see more and more state legislators introduce legislation that privatizes and continues to dismantle our public schools, because if teachers are, if their demands are reduced to a pay raise, right, I think that allows policymakers to introduce something in addition that's comprehensive like that. So I think that's what we're going to begin to see in the next year more so.
Anything in South Carolina in particular?
So I would like to argue that something already is happening in South Carolina. I mean, we have this is called SC for Ed. There's 21,000 members, on Facebook for whatever that means. But we see discourse in South Carolina that we haven't observed since the late 1960s about raises, about public education. The state's major newspaper, the Post and Courier, just ran this 5-part series called Minimally Adequate. So we see a lot of discourse and discussion in ways, I've only been there since 2011, but I've never seen it since that time, and a lot of others really haven't. It's sort of this generational push. So they are already having an impact. It's that slow as molasses sort of movement, but it's happening, and the needle's slowly starting to already sort of move a little bit.
So Aaron, you already raised the question that we need to watch and see what happens next in West Virginia. Is there anything else we should be paying attention to? Do you, you've been writing about teacher shortages, rural communities. What if, since we were seeing West Virginia unfold now, what else should we be keeping an eye on?
Yeah, I think we should definitely keep an eye on the bills that are going to be coming forward, particularly out of the Senate in the remaining few weeks of the legislative session. Because I think that'll be a good indicator, not just of what the priorities are right now and how teachers will respond, but what the long game is. If we listen to Senator Carmichael talk about the loss or the killing of Bill 451, he doesn't seem entirely defeated, which makes me think that perhaps we'll see some more attempts at legislation come through, and I would not be surprised to see the teachers union flex its muscle, because it had some pretty impressive results in the past week.
And Susan, do you see any sign of a walkout in Philly on the horizon? And also there's a heated debate in your state about addressing some of these funding issues, and particularly sort of cyber charter fraud that we've talked a little bit about. What's going to happen there?
I don't think there will be a walkout, because I think in Philadelphia, the teachers union and the pro-public education movement, which is much bigger than just the teachers, is much more engaged in the political structure, and is starting to have a few victories. So this is a very small anecdote, but I think it's telling. Philadelphia has been privatizing its schools since 2001, really, by turnover of public schools. There was 1 year where they let the parents at the 3 schools that were targeted for turnover vote on whether to go charter, and they all voted no. And they were all very passionate about saving their so-called failing school as part of their community, because these were parents who hadn't chosen to go charter, and they really didn't want to. The upshot was the district stopped letting parents vote, and they turned over some others later anyway. But I do feel like nationally and even on a local level, there's, maybe I'm naive, but a majority of people who do still believe in the citizenship and public part of public education, that they value it, and that it's not just a teacher paycheck issue, that there's something really at risk with the privatization movement. So I'm guardedly hopeful that we can build on that.
Does anybody have any questions? Sir, in the back.
Suggested a modest raise, which wasn't enough.
throughout 40 years or more of a Democratic administration. It's just interesting, and my Republican friends that were in the legislature for a long time would say to me, how'd they get there? It wasn't us. Why are we taking the brunt now? We're trying to do something, and I think really they got hurt last year feelings. You can believe Republicans have feelings hurt. But they did, and it raised them to an ire that they did some things that we were able to control as a state board talking to them last year and not having charter schools come up to where all once this bill comes up. Nobody talked to the state board. Nobody talked to the administration. Nobody talked to any PTA, any citizens group. It was this there. And I think it was partially retaliation. But it was a perfect storm. And maybe it could have been handled differently. I don't know. But it just, it's been a bad year, let's put it that way. Because there were so many good things in that bill. They're probably all gone now. I'm not even sure the grades are going to be there listening to the Senate. And the teachers are in box because they said it's not about the South.
Well, that's a less hopeful note, I guess, than the last panel ended on. But I think we're out of time, and I want to thank the participants for a great discussion.
Yes, that was. Yeah, well, the teacher strikes and the walkouts and the teacher activism generally has been something we wanted to pay tribute to because it's been so impressive, so inspiring. I mean, it really did spark a national movement, and I think we've heard from those perspectives here, and I think that's my purpose for inviting all of them, and I think they did a terrific job. Could we give them a hand? So I would like to, while they're exiting, I would like to invite my colleague, Professor Suzanne Reese, to introduce our featured speaker for the morning. Anytime, you can probably give them a couple seconds.
Yeah, I'm going to.
Thank you.
Good morning. It is with great pleasure that I have the honor of introducing Governor Robert E. Wise, known to West Virginians as Bob. Bob has dedicated his life to public service, much of it advancing education opportunities for public school children. Bob was born and grew up in Kanawha County. He attended George Washington Public High School in Charleston, where he competed in track and field. The competitive spirit that led him to half-mile and mile races was an indication of the energy he would bring to a long career in public service. Bob is a graduate of Duke University and the Tulane University School of Law. After he graduated from law school, Bob returned to West Virginia and opened his first law practice in Charleston. While starting law practice, he dove into public interest work. Bob lent his expertise and energy to West Virginians for a fair and equitable assessment of taxes, a citizens group that advocated for property tax reform. Those taxes help fund public schools, and libraries. In 1980, Bob was elected to the West Virginia Senate. He was endorsed by the West Virginia Education Association and other labor organizations. Bob served as a member of Congress from 1983 until 2001. During his 18-year tenure in Congress, Bob served on the House Committee on Education and Labor. He focused on improving financial aid for college students and early childhood development programs. Bob was then elected governor of the state of West Virginia. As governor, he was able to move forward with his education agenda, fighting for and signing into law legislation that funded the Promise Scholarship Program. Promise has enabled thousands of West Virginia high school graduates to continue their education in the Mountain State. During his administration, West Virginia saw a significant increase in the number of students completing high school and entering college. As governor, Bob also implemented comprehensive early childhood education programs. Bob recently completed 14 years as president of the Alliance for Excellent Education, a national nonprofit dedicated to ensuring that all students graduate from high school ready for success in college and work. Bob's accomplishments include leading the development of future-ready schools, a network of 3,300 school districts committed to the effective use of digital learning to assist teachers and improve student learning outcomes. He launched an adolescent learning initiative to guide education policy and practice decisions. While president of Alliance, Bob authored the book, Raising the Grade, How High School Reform Can Save Our Youth and Our Nation. Bob is a prominent speaker and advisor on education issues and trends. He has advised the U.S. Department of Education, the White House, and key state and federal policy makers. He also holds a black belt in Taekwondo. Again, it is my great pleasure to welcome Bob to the West Virginia University College of Law. So here's Bob.
Thank you very much, Professor. And it is true. Boy, you've done some research. I can see why you're so good and have been all these years clerking in law and academe, that you knew that I did track and field. So why did I do track and field? Actually, this somewhat summarizes my whole presentation. I did track and field because I couldn't do football. I wasn't qualified. I couldn't do basketball. You've ever tried to play center at 5'10", 110 pounds? It turned out that in terms of my particular athletic, which I also can equate to learning, needs, track and field was what I was suited for. And that's what, so here's my one-liner. You can go get coffee now if you want, because where I think we ought to be focusing, whether it's litigation, policy, or whatever, is what are the individual learning needs that each student has? And that, to me, is the progression of Paulie. How's that for a succinct argument, Professor? But you don't get away that easily. So let me talk some, because Paulie, the 40th anniversary of Paulie is actually, as I started doing some research and reflecting, it occurred to me that Paulie is an odyssey. It's an odyssey in the law, it's an odyssey for education, and it was a personal odyssey. So let me mix it all in. The Paulie case is some extremes for me. I was on the plaintiff's side, an expert witness in the Paulie case. When the Paulie decision came down, Judge Recht was appointed as a special judge, and he held 40 days of hearings. I was an expert witness on the subject of property taxes. We'll get to how come Bob got to know about property taxes shortly. But I was an expert witness on property tax, so I was on the plaintiff's side. 20-some years later, I'm the defendant, as the governor of the state of West Virginia, and I signed off on the final order that Judge Recht issued. So I've been on all, it's a perfect, Judge Starcher, you'll appreciate this, it's been a perfect political situation. I was on all sides at one point or the other. But it also presented challenges too, and maybe that's, if I could talk about some, because as you do litigation, it does present challenges that are outside the courtroom. The challenges of implementation, the challenges of even when it's right, but if you're an economy that's in a tailspin at the time and you're being called upon to expend significant amounts of money. So there were lots of challenges, and I do want to note and recognize, and as I did last night, I want to recognize the Supreme Court of Appeals in 1979 that issued the Paulie decision, but also then set in motion the special judge in mastery of Judge Recht, who I think may be one of the finest jurists that I've ever run across, but also who over time, over the 20-some years of this case, was coming to grips with not only what was happening in education, but what was happening in the state, and how could he move forward and at the same time take that into consideration. So there are three main periods in the Paulie case. First was 1979 when the Supreme Court took it up, remanded it back, said the Circuit Court in Kanawha County was wrong, and appointed Judge Recht. So 1979. Second period was 1982. That's after 40 days of hearings. Judge Arthur Recht issues, I believe, a 244-page opinion and sets in motion a judicial, legislative, and political process. Indirectly, I was in politics because of the Paulie case, because the furor that came out of the Paulie case, and then subsequently Judge Recht, launched a movement, teacher-led, but others as well, to elect public officials that would represent what they thought was important in education. And I won a state Senate seat in that period, as did several others. The state Senate actually flipped control, not Democrat to Republican, but flipped the philosophical control based upon the Paulie case. And then the third period, so we've got 79, we have Judge Recht's first decision in 1982, and then we have Judge Recht revisiting the case. Remember, it's been open for all these years. Master was appointed, the State Department of Education was assigned to develop a plan. The legislature went and made several attempts at addressing it. And then the plaintiffs in the Paulie case, by this time the Paulies had aged out, the plaintiffs in the Paulie case came back in the case Tomlin, the Lincoln County Commission. They found new plaintiffs, said not enough has been done, and pressed Judge Recht to continue along the same direction he's been and to order new funding in certain areas. And at this point, Judge Recht said no. And so there, in my book, while there are 2 to 3 significant developments in the Paulie case over the 20-some years, there are really 2 during the Paulie case. There are 2 generations of education changes that took place, and we're now in our third. And so I also want to address some about the third. The test of a case to me is not in its immediate impact, but its relevancy and its ability to be relevant and to continue its relevancy in changing times. And I've just mentioned the periods that the Paulie case went through. There's some constants in the Paulie case, so let me just point out what those are. We referenced earlier the 8 principles that the Supreme Court enunciated in 1979. In terms of today's education, they're not necessarily in the right priority list. They're a bit clunky in their wording. They're not sophisticated, but I'm going to hang on to them because I can work with them. The one that I think is most significant in terms of reflecting what needs to be built from the Paulie case is the one that I'm actually emphasizing, although I think it was number 5, and that is self-knowledge of the total environment to allow the child to intelligently choose life work, to know his or her options. I need to extrapolate a little bit on this, and you'll hear this theme throughout the rest of my remarks. To me, what that is we have to be continuing to prepare our students to learn how to learn. Simply learning math facts, how to multiply and divide, that's one of the constants in here. Simply learning literacy, key core competencies, they are no longer sufficient. You have to be able to be engaged in critical thinking, creative thinking. You have to be able to collaborate. You have to be able to synthesize. Everything that you learn in law school about taking 4 or 5 facts and then synthesizing a conclusion, that's what now is commonplace in almost every aspect of the workforce, from the most traditional to the most transformational industry. I say all this because I'm not here as a jurist. I started down the road with the Paulie case as a witness, as a lawyer, yes, as it was mentioned. But I want to speak to you more as later a politician. I happen to think that the term politician can be an honorable term. It comes from the Greek Pauli, those who administered the city or state. Seems to me to be a pretty honorable way. Got abused along the way a little bit the last 2,000 years. And then also as an advocate, because in the last 14 years, I just retired, or did not retire, repotted, rejuvenating. But in the last 14 years, as head of the Alliance for Excellent Education, I have been an advocate. I wish I had known what I've learned in the last 14 years. I wish I had known as governor, because I would have been a lot better for education. But be that as a way. And I do want to recognize my colleague, graduate of the law school, just stepped off the advisory board for the law school, Chip Slavin, who's still with the Alliance for Excellent Education. Chip. So there are some other findings in the Paulie case that are also constant. And then I'm going to get to what's changing. The finding in 1979 that the future of West Virginia depends upon the quality of its education system. It was important then, as a friend of mine, as a high school classmate of mine said, that was before 1979, as a high school classmate of mine noted to me one time, education is the only passport from poverty. It was true in 1966. It is really true in 2019. This state's economic future, its future in a lot of other ways too, depends upon the quality of its education system. And the fact, it's not only the quality, it is the fact that what it is able to do for its students and how its students are benefiting. Paulie and Judge Recht noted that. Also, the definition, and this is another constant, the definition of a thorough and efficient education must be ready to adapt to changing economic and social times. In Paulie's day, we had 50-some thousand coal miners. Today we have, I believe, we're somewhere around 13 to 15,000. I might add, they're mining far more coal than they did because of technology, surface mining, and other things. But in the Paulie year, in 1979, we were still the height of manufacturing, mining industries. Shortly thereafter, they began to take a decline, and they never came back, and particularly in manufacturing. But so what Paulie tells us, even then, is, and then Judge Recht in '82, is that education and the economy are going to be facing constant changes. So some valuable lessons from the Paulie case. First of all, it's been stated earlier, elections matter. I'm going to submit to you that there are two places that critical education decisions are made. One, the thousands of decisions in West Virginia that are made every day in classrooms by classroom teachers affecting their students. Looking at data and analyzing who's doing what does this child need, what does that child need, speaking to a parent. Those are critical decisions. That's one form. The second form is every important decision and often unimportant decisions in education will be acted upon by an elected official. A local school board member, sir, you were talking earlier, the state board member who is appointed by an elected official, confirmed by an elected official. Judge Recht and the Supreme Court are elected officials. The member of the United States Congress who enacts the next piece of federal legislation, the President of the United States, and so on. Every important decision is ultimately passed upon by an elected official in education. Education is a political process. Don't try and say it's not. What you want to try to do is to make it work. So understanding that, because that means that litigation has consequences. And certainly we saw that in Paulie, and we also saw it in a somewhat companion case I argued with several other public interest advocates also ruled on in 1979, Tug Valley Recovery versus Mingo County Commission, which upheld that a third party in a county, a taxpayer in a county, had the right to go and challenge somebody else's assessment as being too low. In this case, we were challenging mineral companies, mineral owners, for having their coal holdings assessed at under what their value was. At the same time, homeowners were being assessed at a much higher level. Supreme Court upheld that right, that a third party could challenge, and Judge Recht then used that in Paulie, and then in his decision to talk about how there were additional sums available to support education because 70% of the property tax dollar goes to education. So, what was the political impact? I was 5 years out of law school. I thought, I've been to the state Supreme Court. Three of us just argued this case and we just won. This thing's going to stand forever. And I learned how long it could stand. It could stand 3 months until the next legislative session, when folks ran back to change who lost, to change the statute to what they wanted it to say. We were able to put together a grassroots coalition that beat them back, but that told me where the power also lay. And so litigation and politics and elections, they work hand in hand with one another. So another lesson when it comes to education is that, and this is one I've really learned the last 14 years, is that maintaining the traditions of previous eras, because our system of education goes back essentially to the University of Bologna about 800 years ago. I just might want to say, we're sitting in an amphitheater. The seats are better cushioned. It's a little more climate controlled. This is what they were doing 800 years ago. And so you saw that video of the before the teacher panel. Did you note something that was very significant? When that student said, what makes a difference to us is we're not sitting in rows. We're sitting in groups, and we're learning from one another. Still traditional values in the sense of a quality teacher who understood what needed to be done, but the pedagogy had been adapted to reflect what the learning needs really are. And so, to me, that's what learning in education, and that's what I think is important about Paulie, is that we have to recognize that what's been traditional and what we may have grown up on is not necessarily what required now for this next generation. And Suzanne, I know you were never involved, Professor, I know you were never involved in this, but when I was doing the research on my case in '79, I did something, I shepherdized. Now, I asked one of you last night, because I haven't been in a law school in 40 years. I asked one of you last night, Stephen, I asked one of you if you'd shepherdized. I said, oh, yeah. I said, yeah, you just go right, LexisNexis. There was no LexisNexis. I'm talking about, Professor, if I go in the law library, are there still they don't still print those long volumes of books, the shepherdizing. I could go down, I could open that volume up. It was all volumes that were somehow tracked to one another, and I could shepherdize. I was so proud I could go and be in the state Supreme Court library and go quicker than almost anybody going. And it would only take me a few hours and then a few days, and you will have it in a minute and a half. So, but think about how then learning, that's not only an aid to learning, that's changing learning. So it's the need to recognize that education is constantly changing. And once again, Judge Recht, in that third decision from 1982 to 2003, recognizes that. Because what was the original Recht decision about? It was about inputs. It was about what it was that constituted a thorough and efficient education as defined by what the system that you build. I am looking at some great jurors. I see Justice Cleckley back on the wall. I'm trying to think whether he sat on that bench at that time. Anyway, and it was how many square feet per student? What did the gymnasium have to look like? Laying out detail by detail what had to be in that system of education. That's 1982. Now flash forward to 2003 and the Paulie decision. And what's taken place, and it was referred to earlier by some of our earlier panels, is we've moved from an input system to actually looking what's happening to students. What are the outcomes? And so the inputs may be valuable, and some of them are essential. I remember walking through one school, visiting one school in a rural county that was the subject of my litigation, and there was raw sewage running in front of it. And you go inside, and it was just an abysmal building. Yes, there should be some inputs dictated there. What's safe and healthy. But what about the learning outcomes? What is actually happening to those students? And so during the time that Judge Recht ruled the first time and the second time, we went through, whether you call it standards-based reform, performance-based of accountability or whatnot. And so the result was that by the time we get to 2003, the focus has shifted to not what are the inputs, but what are the output, what's the outcome. And I would submit to you that we're now in a third generation, and I may get to talk about that a little bit in a minute, where there's actually a combination of the two. But when Judge Recht issued that first decision in 1982, it invoked raising and spending additional funds, a lot of them. And in that one, money mattered. Money matters now too, don't get me wrong. But money was the main thing. And now you look to 2003, and he revisits his decision in Tomlin v. West Virginia Board of Education, and reflects the standards-based movement. Now, I know this weekend, this Friday, right? So you could do Netflix and all of that, but you don't. Here's the binge reading you want to do. You want to do binge reading. You want to read 244 pages of Judge Recht's decision in 82. Then go forward and pick up Tomlin in 2003, much shorter. But it will give you a complete picture, as only Judge Recht could write, a complete picture of the evolution of education. Let me quote from Judge Recht in Tomlin. The performance-based accountability approach is designed to spend and allocate resources where they're most needed, instead of allocating resources at the beginning of this educational cycle with the hopeful expectation that the results will achieve the highest quality standard of education. This front-end approach was the underlying premise of the master plan, only because clear and convincing evidence submitted during hearings between August 1981 and January 1982 allowed no other conclusion. Think of that evolution that had taken place in both his mind as well as in education in the state and particularly nationally. The line of Recht decisions shows a careful balancing of constitutional requirements with current context. For 20 years, as I mentioned, the standards movement had been building. It culminated, Judge Recht issued this in 2003. It happened, the standards movement culminated federally with No Child Left Behind being enacted in, I believe it was 2001 or early 2002, bipartisan agreement. Most significant involvement in some people's terms, intrusion in others, by the federal government into state and local activities in decades. And some would argue, and I would argue in some cases, overly prescriptive, but I would also say that without this, what No Child Left Behind will do for you if you choose to get involved in education litigation or even education policy, it provides you access to data that we otherwise didn't have, because never before did we look at what was happening to individual subgroups within a school. We would look at the school. Good news. XYZ High School has an 85% high school graduation rate. What you didn't see was that there was a significant group, students of race or color, students with disability, students, low-income students in a largely middle-income to upper-income school that were either dropping out or not succeeding. I remember visiting a U.S. senator one time, taking to him a list of what we call dropout factories. They were graduating less than 60% of students. One of them was his school, his high school that he graduated from, and he looked at it and said, "Oh, I love this school. It's wonderful. I went to Harvard, so-and-so. Here's the staff person. She went to Brown. Wasn't it a wonderful school?" He never realized he had two schools within a school. He had one school that was white, essentially, and he had another that was black. And one group of students went to the AP courses, and the other group of students dropped out. And the data masked it. Now that doesn't happen, because now subgroups are accounted. And so that has been one of the, and so that No Child Left Behind comes along just as Judge Recht is wrapping up his decision. I don't know whether he fully appreciated what it was going to mean, but he could see the direction that things were going. 2003 REC decision also seemed to balance economic realities with what would be achieved, against what would be achieved. And I'll give you an example. Remember 1898, that's me. Remember 1982 was about inputs and money, and a lot of back and forth in the legislature about how much this is going to cost and constant tug and pressure. In 2003, the plaintiffs come back, or 2002, the plaintiffs come back and they not only want more rigorous master plan, but they also want the judge to order more money yet to be spent and added to the county formula, basically around transportation. I want to read, Judge Reck declines, and I want to read to you the language, because this also reflects the shift that has taken place since 1979. Judge Reck writes, he declines the plaintiff's request to mandate an additional $43 million, stating that, quote, what the evidence did not establish, however, is that while the formula adjustment would infuse much needed financial resources to each county, the failure to effect the formula adjustment would not result in the inability to provide a thorough and efficient system of public education as required. He's asking now for justification that the additional funds will make a difference, as opposed to simply saying we need, it is desirable to have this kind of additional money for transportation in the county formulas. Why did that make a difference? It made a big difference to me, because I was governor, and we were entering the worst recession since the previous worst recession, when in 1981 or 2, and we had just given the largest pay raise to teachers that they had gotten. That was my first year. Thank you, Gray Machines. The largest, some of you know what I'm talking about, the largest pay raise to teachers that they'd received in probably a decade. And we were online to give another one, and then the recession hit. And West Virginia is slower going into a recession, and it's slower coming out. And so what we realized was that in the next year, we weren't going to be able to give that pay raise, but we were going to have to freeze salaries. In that point, every $20 million represented 1% pay raise a year. That $43 million, not only would we didn't have it for pay raises, but we would have had to have taken it out of some other aspect of functioning. Probably higher ed, to be quite frank with you, because K-12 is constitutionally protected. And so what I appreciated about the judge was him saying, if you can't show me that it's going to make a difference, and that then I'm going to decline to order it. And so I think at that point, some economic reality and impact was setting in as well. So the Paulie case was filed in one educational and economic context. It was finally settled in another, and now it exists in a third, and now there's a third. And so let me talk about that, because that also reflects where I've been the last 15 years, essentially. So what students needed to know in 1979 and what they learned and how they learned were vastly different. Think about it. There was no internet. Little focusing on, actually, three, if you didn't have cable, still new. If you didn't have cable, there were 3 network stations, 1 public TV station. That was it. And they signed off at midnight. I know it's hard to believe, trust me. So what students needed to know in 1979 was vastly different. There was a little focusing on how to meet the needs of each student. We treated students as a group, a block, your class. Ergo, this is what happens. There was no clear understanding that post-secondary education would be necessary. The thing that mattered, you had a library, you cared about how many books were in the library. There was no internet search engines. Graduating from high school meant a student, according to a Harvard study that I like to cite, graduating from high school in those days meant a student already had 50 to 70% of what they would need for their lifetime success. 50 to 70% by having that high school diploma. And while economic change was soon to come to West Virginia in a very hard and dramatic way, manufacturing immediately, chemical and steel went through, and the rest of the country too, but the rest of the country caught a cold and we got an extreme virus. because we were so dependent upon manufacturing steel and extraction. And when it came through with a vengeance. Then Governor Rockefeller, 1976 or 1977 to 1981 first term, he presided over the fastest growing economy in the country. 1981 to 1985, he presided over 24% unemployment. And so you can see the massive changes that were coming in 1979, and also the learning differences. Now, let's go to 2003. Internet, well established for commerce, communications, and learning. Online learning was developing. I remember giving the commencement speech. Anybody here from Pickens? Randolph County? So I gave the commencement, just Archer, I suspect you may have given one of these. I gave the commencement speech at Pickens High School. Those of you who know that area, it's one of the most remote spots of West Virginia. You go up 25 miles, up a couple of incredible mountains to 3 communities where there are incredible people. And I gave a commencement speech and I had a graduating class of 2. They told me if I came back next year, it actually was doubling to 4. And the joke was everybody gets to be valedictorian or salutatorian. What impressed me, what impressed me about that commencement speech was there were 2 students graduating, 100 and some people in the audience. They weren't all relatives. Those were the 3 communities coming together to say, how proud we are of you. But as I walked out of that commencement speech, thinking how remote we are, I said to the principal, how in the world do you get, I guess there's so much you're not able to provide, K-12 school, pre-K-12 school. And I said, particularly languages, how in the world do you get good language, any language instruction here? And he said, what are you talking about? He said, I have one of the finest Spanish instructors in the country. And I said, here? And he pointed to a satellite dish, a little old technology then, pointed to a satellite dish and said, she comes in every morning at 10 o'clock from San Antonio. And so we were beginning to see since 2003, we're beginning to see the development of technology that enhanced teaching, not replacing it. You will not replace, nor should you try, what the human teacher provides, because there's an empathetic and quality teacher is the single greatest determinant of success, school-based success in a school. But technology has the ability to provide and assist that teacher. As one superintendent said to me one time, you came to see our technology. It was a pretty sophisticated operation. He said, that's not what we're about. We're about the teaching. And you ought to know that what we look at this technology doing is it enables our teachers to be professionals. Everyone is now, and I love these words, an educational designer, because they have the data so that your learning needs and your learning needs and your learning needs are now, a teacher can deal with each one of them individually as opposed to treating us all as a group. Anybody like to go to a doctor and they say, well, let's see, Bob, you're X amount, you're 70 years old, so I'm going to treat you, here's a whole lot of data on 70-year-olds overall. You probably got bad knee, you got a bad hip. I'd just as soon you looked at the data on me, thank you. And I do have bad knees. But what else is good about me, and what are the things that we need to focus on for me versus what we need to focus on for the next 70-year-old and so on. And so that's what technology has the capability of doing, enhancing teachers. And sometimes a bad term, data-driven decision-making. Do you really want to make, if you're going to represent me, I hope you're using the best possible data as you make your decisions about whatever legal venture we're in. And so the same thing needs to be true for education. And we have that capacity much more now today than we did then. So so back to the learning needs for 2003, or post-2003. So now let's go to, let's see, you're all, so a first grader who enters in 2003. The Paulie case has been resolved. Judge Recht has signed the final order, and now you enter, a West Virginia student enters school. What have they seen since 2003? Their schools may have libraries, but every one of you here who's a student looks to Google as your main search engine and where you acquire knowledge. And you will for the rest of your lives, or to whatever the next the next variation is going to be. Broadband access is not a luxury anymore. It's a prerequisite. And in fact, the federal government is working under a mandate that 99% of all classrooms, 99% of all students have access to broadband within their schools. We're not there yet, but we're getting much closer. And then the ability to extend it, and this becomes even harder in West Virginia with our terrain, but the ability to extend it to homes, because it's pretty tough if you have the most modern technology and learning opportunities in school and then to go home and not have the same access. So how to accommodate that, or at least how to adopt the strategies so that perhaps you're taking home a hardwired computer with certain information on it and you're coming back and you're using the internet for other learning experiences. Anyway, I think what else that student who came in the first grade in 2003 is seeing. Facebook, smartphones. 2008 was the smartphone. 2010 was when the first tablets came out. Chromebooks, social media, increased interactivity of technology. I went to school and our technology is we'd see a video. Okay, that's a one. Some of you may have taken an online course, but it was asynchronous. You didn't get to interact with the person. Today, the technology is about interaction, and soon we're moving into the world of artificial intelligence and a number of other areas as well. And so learning is an incredible new experience. And remember that statistic from when I graduated from high school, and 50 to 75% of the knowledge was already acquired that I needed to be successful in life. Today, it's 2%. And so the issue isn't, the other piece of it is, if human written knowledge doubles every 5 years, that's a conservative estimate now, then since 2003, 2008, 13, well, we've doubled 3 times. And yet I got to be honest with you, my brain hasn't increased correspondingly. It should be hanging down over lobes over my ears. And so what that means is that this is not just about knowledge acquisition, it's not just about knowledge memorization and retention, it's about acquisition and how to acquire. And the reality also is that where I was going to be re-educated in 1979, 3 times during the course of my career, you're going to need to be retrained in some way 10 to 12 times by the time you're 40. And so what we're talking about in a thorough and efficient education today in West Virginia and across the country is about lifelong learning and preparing a student always to be able to learn. You're going to talk to some of you last night. I understand you're taking the bar exam. Chill. You're going to be doing a lot, but that's just the start. And because you're going to be constantly now learning, but you're not the only ones. So if I could, and come back to just a moment about the importance of critical thinking, creative communication, and collaboration. Those weren't referenced a great deal in the Paulie decision. Interestingly enough, if you took a survey of the Forbes 500 companies back in the early 80s, they would pretty much list what in Paulie, the Supreme Court listed as the priorities in the order they listed them: core academic content knowledge, ability to do sums, and so on. Today, the order has flipped. And core academic content knowledge is still important, don't get me wrong. If you're going to synthesize, you're going to have some knowledge to start synthesizing with. But now what an employer is looking for is the ability to communicate critical thinking. And that goes from the most traditional industry to the most transformational. I visited a coal mine when I was leaving office in 2004. They were hiring 140 new miners for a deep mine. And I asked the owner, what is the education level of most of your new miners? And he said, everybody has high school and most have post-secondary. And I looked at him and he said, Bob, he said, if you think I'm letting somebody get a mile underground with a $500,000 piece of technical equipment, you're crazy without post-secondary. And so 12th grade is no longer the goal. And that's just a personal plug. And I don't know whether this was in the plan that the legislators were considering or not. We all focus on grade levels. I'm going to make you a prediction that in 10 years, grade levels are going to be increasingly obsolete, and that we're going to see the seamless need of competency-based advancement. So a student advancing based upon what the mastery they demonstrate versus how old they are and what grade that requires them to sit in. The other thing is we have 180 days required K-12 that you stay in, you be in a seat, that's called seat time, in order to get a degree. I don't know, anybody bought a car recently? Did you go and ask him, I want to know how many days it take to make this car? Or did you say, what's the quality of this car? So we have the ability, and where learning is going to be going and where thorough and efficient education is going to have to rise or fall on is the ability to determine mastery, not simply seat time and other arbitrary, what is increasingly arbitrary. A couple other statistics, I love data. That student started in 2003, 65% of those children entering school today are entering school and being prepared for 65% of the jobs that these students will be filling, we don't know what they are. They haven't been created yet, but they will be. And so once again, we can't be training people for a particular task that they're going to undertake all their lives. We're going to have to be training them for a certain types of occupations and then the ability for them to continue educating themselves. And finally, I've got this study I always like. Georgetown University Institute reported that when the Great Recession ended in 2010, there were in that 5-year period afterwards, 2010 to 2015, there were 11.6 million new jobs created in this country. 99% of them went to people with more than a high school diploma. High school diploma or less was 1%. So it's not, once again, it's not necessarily saying a 2-year degree, a 4-year degree, law school, med school, whatever degree. It is saying post-secondary is vital. And so once again, what's a thorough and efficient education? It's preparing students for the next level of education. And this goes to, I think it was perhaps your discussion and others, which is legislatures have to understand that if you're going to mandate higher standards, which you need to mandate, you need to recognize, at the same time, this is not a process that stops at 12th grade, stops with an AB degree. It's a process that's ongoing. And so a thorough and efficient education is going to involve a lot more than what Paulie was. So anybody interested in some future litigation? I got some thoughts for you. First of all, remember that the definition of a thorough and efficient education has to reflect current student learning needs. And this means a set of standards for high standard. All states have now gone to college and career ready. They're still trying to figure out exactly what that means, but they understand that's essential. The second point I would make is that the original REC decision was about inputs, square footage, dollars spent. To the extent that inputs are important, I think we ought to be looking at a different set of inputs. What's necessary, what will be necessary for any modern learning environment? We've had a panel on teachers, so let's talk about teachers. Treating teachers as professionals and providing not only adequate salaries, but also the highest quality professional learning experiences. What is it that this law school, as most law schools across the country, gets a lot of attention. It's always one of the things that a university points to, the law school, the med school, the College of Engineering, and so on, College of Arts and Sciences. What about the School of Education? Because the School of Education is what's preparing the teachers that will affect all of us. I was in office only a short time when I learned, and I was all about economic development, every governor is, and we developed, and Chip can tell you this, we developed a swag. You couldn't walk into West Virginia without me giving you something if you were an employer. I mean, we had new tax incentives, I don't think we ever did property tax abatements, but I could loan you money interest-free in more ways. So you walk in and I give you a swag bag. What I learned real quickly was, in workers' comp, we'd help you with that, and we'd help you with regulations and stuff. What I learned real quickly was, the first question an employer would ask me was they would ask me about the education system. And they asked me about the education system for two reasons. And this goes directly to Paulie. They asked me about the education system for an overt reason, because they want to know what the quality of the workforce is going to be. Are they suitable to work? Or how much time and money am I going to have to spend training them? And are they trainable? That was the overt reason. What's the covert question they had? Because if I'm sending my children to West Virginia, or I'm asking my friends whom I work with every day to move to West Virginia, I want to know what kind of schools they're in. And so I quickly learned that the single greatest economic development package in our state was the K-12 system, followed by the higher ed system. Why did I work so hard on the Promise Scholarship? Because it was about retaining students at home and people understanding that if they worked hard and got the requisite grades, they would be able to go. And incidentally, not just the Promise, but also the HEAP and HEAF, those scholarships have meant that we retain, if I can keep you in West Virginia to go to into WVU or institution of higher education, 80% of you will stay. And that's the single greatest asset that we can have in this state. We raised the college going rate to 36%. We're still, unfortunately, and I noticed you cited this in an article, Josh, we went from, unfortunately, I believe we're still 50th in the nation per capita in 4-year degrees. I can't change history, but what we can do is begin altering the future. And so the college going rate is now 36, with 36 in the nation. Now we got to work on persistence. Anyway, subject for another day. But let's talk, when we're talking about inputs, let's talk about teacher preparation and what teachers need, and treating them as professionals that they truly are, and providing them the professional learning communities that are so important. This country, not just West Virginia, this country of all the developed nations requires our teachers to be on the feet in the classroom more hours than any other nation. Every other nation gives more hours for professional collaboration. Think of the times that you spent working with each other in study circles and things like that, and how valuable that's been. What about if they told you, here are 15 files, go down to the courthouse and just argue all day? So what is it that we can be doing to address that? School consolidation, sometimes necessary. There's no way around it. But do we also now have the technology to assist some schools that are centers of their communities to stay open that we didn't have 15 years ago, and in which Paulie actually drove some schools to consolidate? I was in Idaho one time, fairly rural as well. I was in Idaho one time, and a teacher, I'm making a presentation on blended learning, and a teacher came up to me and said, they say if we introduce technology in our school, and this was a very remote part of remote Idaho, if we introduce technology in our schools, then we're going to have to close our school. And I was thinking back to my experience and told her the reality is that if you don't have the proper technology in your school, that school definitely will close, because you're not able to offer the students what they want, and that's what Paulie was about. Now we do have the opportunities to enhance the role of the teacher. Third, the primary focus of funding should be on what the individual student needs to succeed, and I've lost track. West Virginia Schools funding formula is always one of the most complex. Is it still 7 steps? And Don, I see you back there, and others that know this very, very well. I realized very quickly that there were only 3 people in the entire state of West Virginia that understood the state funding formula. That's why they were so much in demand. And they held the keys to the temple, but I know this, is that it's not weighted enough in terms of what our individual student needs. And so here's a proposal that I'd also like to make, and it was actually discussed by Zoe and others in a previous panel. And so a thorough and efficient education doesn't begin with just walking into the school, because each one of us brings into that school whomever we are and whatever our environment is. And so is there now a grounds, building upon Paulie, building upon the REC decisions, building upon other litigation, is there a grounds to argue that a thorough and efficient education requires a whole child approach, looking at what it is that that child needs to be truly able to learn to the maximum of their ability? So what kind of services, for instance, what about mental health? Ever tried sitting for an exam or listening patiently in class when your teeth hurt? What about, or you're not feeling well, or you're hungry? And so, and then can that then lead in turn to what was described earlier as a braiding of services, so that rather than having social services strung out all over a county, what we're doing is consolidating them at a point of contact, perhaps a school, perhaps a community center. But what we're doing is recognizing the whole child. Now, does the whole child sound like something new age or really squishy and soft and out there? Well, it's pretty new. John Dewey was writing about it in 1898. And as well as a whole other line of educational scholars. So, and to those who may be thinking, oh, Bob, there you go. We always knew that down deep you were one of those liberal do-gooders. I would argue that this is the most conservative thing you could do, because for the first time you're taking services and combining them and making them cost-effective and delivered at a point of contact as opposed to ineffectively across several different agencies. Do you know how... I did an audit, and I promise, Professor, I'm going to wind it up pretty soon. I did an audit when I asked an audit. I didn't do the audit. I convened the Children's Cabinet in 2001. These are the department heads that have jurisdiction over some programs affecting children, education, Medicaid, juvenile justice. And I said, how many programs do we have in the state that serve children? Nobody knew. So we went back and we did, and I called it an audit, maybe it's an evaluation. Anyway, we did an analysis. Came back, took 2 or 3 months. We had 267 separate programs in the state of West Virginia that affect children. 267 separate lines of funding. 267 different delivery systems. Now, every one of them was well-intentioned, but they built up over 30 or 40 years. And now what we've got is this mishmash across agencies. That's not cost effective. So the most conservative thing you can do is braid those together and make sure that that child who's in that school is getting those services in the most effective way so that they in turn maximizes their learning opportunities. So the Paulie decision attempted to equalize and improve the conditions, physical and academic, for all West Virginia students. And as Judge Reck noted in 2003, this was the best tool he had at the time. So if Paulie were being filed today, would there be new grounds to argue? I suggest that emerging data and research and using the science of learning, great gains have been made in just the last decade, should guide today's policy decisions. Some quick thoughts. Traditional concepts of equity are now inextricably joined with economic imperative. If you've got 50% of your children in this country who are children of race, color, ethnicity, and or low income, it's not just a moral imperative, which it always has been, it's an economic imperative too, because they are not only the workforce, but they're also the consumers of the future. When you're a lawyer, they're not going to be, folks making $15 an hour aren't going to be walking into your office, unless you were like my office, which was legal aid. They're not going to be able to walk into your office. And so we have an equity and an economic imperative that are now inextricably adjoined. I like to say, for the first time, the Bible and the billfold, right there, one and the same. The research, second, if you're going to pursue policy or litigation, study the research about the importance of early childhood development. That's long-standing research. But be aware that there's now a whole body of research emerging on the fact that adolescence is its own unique period of development. And that has great ramifications for the decisions you're going to make on secondary schools. We can't just love kids now until they're 7 or 8. We've got to love them all the way through. And so the science of learning should be guiding a lot of our policy and our practice decisions. And speaking of secondary schools and preparation, once again, each child has unique needs. And so using data, technology, and to develop those learning pathways is critical. Once again, looking at the tools and training that our teachers need and require. This is a profession. It is not a trade. It is a profession. And teachers have been forced in many times to conduct themselves as a trade union because they said their trade unions are making the money and we're not. That was 50s and 60s. This is a profession, and we ought to treat it as such, pay as such, and recognize that this teacher is not only the one working with our children, but also working with our economic future. And so finally, and speaking one more time on that teacher, a friend of mine was in Singapore, and he got me on an education visit, got into a cab and asked to go be driven to the Ministry of Education. Singapore is about the size of West Virginia in terms of land, actually half the size of West Virginia in terms of land, about twice the size in population. And so the cab driver said oh, you're going to the Ministry of Education. Teachers, they're our nation builders. Teachers and educators are our nation builders and our state builders here. And that's what Paulie, I think the message of Paulie continues. So in closing, sometimes one of the most blessed words a former politician can say. In closing, Paulie may not have led to an explosion of greatly improved student learning outcomes, NAEP results, other test scores, unfortunately, but then again, I haven't seen that explosion take place in other parts of the country either. Some places better than others. But we have seen high school graduation rates increase. We've seen college going rates increase. West Virginia does have one of the most effective early childhood 4-year programs in the nation, nationally recognized. We've got a lot more to do. But what Paulie has done is focus on the importance of education and establish basic principles and guidelines for asserting what should be a thorough and efficient education. And most importantly, what Paulie has done is recognize that while the need for quality education remains constant, what constitutes a quality education, and how it is measured is always changing. And our students and the future of the state require the best of the constant and also the changing. Thank you very much for your interest.
Thank you. That was excellent, Governor. We're going to adjourn now and reconvene in the event hall for lunch and the keynote speaker.